May I have a lawsuit's leave to pay for moving one urgent unlisted motion tomorrow?
Tomorrow?
Tomorrow.
Yes. What is the urgency?
Urgency, book fair is going to be held on and from 28th. This is being moved by an organization, Vishwa Hindu Parishad. For the last 20 years, we are having stall over there. This year, we also applied. In the lottery, according to us, this was held, we were not called for. Repeatedly, we contacted with them. Ultimately, they even refused to take up the phone call also. So, I know your lawsuits order, last order, but that's not that. We are publishers also. And according to us, this is a public event because 1.7 crore.
No, 1 minute. You say that you fall under Article 12.
Not on I, not but
the guild falls under Article 12, and you are a publisher.
I am one of the publishers, and we booksellers, everything. This is a worldwide organization. It's not that.
No, its organization is different. Thing is whether you qualify within the
yes, because otherwise, how could I help for the last 11 years?
That I do not know. Possibly that was not the. If I can remember correctly, submission was that is not the condition for the last.
All right. I get your losses. I get your losses.
But then. Do you still think I have expressed my mind in the last order?
To that, I can satisfy. So for the public event, I will join an issue with your losses finding. But unless I touch your losses code, I can't go. Even if your losses. But I am satisfied about my case that I can convince your lordship that this is a public event. Because I tell your lordship 1.7 crore is being explained by expenditure is being carried out by the government. All the tenders for the book fair are all by the government departments and municipalities. How can it be said, that this is not only by guild? This is the worldwide function.
And since when is the fair going to be held?
28.
I do not know at such a last stage what the.
That's why I'm paying your losses leave to move it.
Come tomorrow.
May I get your losses?
May I have your lordships? May I have your lordships sign leave to mention an urgent matter, my lord. This is pertaining to a tender by Coal India Limited. The pre-NIT bids have already elapsed, my lord. The procedure has been set into motion. I'm praying for urgent listing, my lord, and leave for short service, my lord. My lord, if I do not move this, my lord, my writ petition would become infructuous. My lord, kindly.
When will the tender bid be opened?
My lord, the pre-NIT meeting has already concluded on 30th December.
All right.
My lord, as per that procedure, they will notify the date in the month of January itself. It could be any day, my lord.
Coal India?
Yes, my lord.
Monday, move.
My lord.
Serve.
Yes, my lord. My lord, kindly.
May I leave to mention? May I leave to mention one matter? I'm a customer service provider under the State Bank of India, but I'm not the direct employee. I used to get help to the rural area regarding those ATM operations, my lord. The rule is that prior to 30 days, I could not be turned down, serving any notice. That rule was not followed. Not only that, my lord, one code used to be generated by the SBI through an agency, and that agency will provide me so that I can make action of that very particular ATM machine. But that has been turned down without showing any reason. No notice has been served.
By the SBI?
Yes. SBI, State Bank of India.
Yes.
And my lord, that I could not.
Where is the matter?
My lord, this is within the list, my lord.
Then why are you mentioning? You want upgradation?
2215.
You want upgradation?
Due to one reason, not that mission, that one person in my place is going to be appointed to operate that particular machine. I have requested them that matter is pending. You could not take any action, even if they are least bothered.
No, but then there is no concept of vacancy over here.
No, unless until they couldn't give any person to that machine, the rural people could not access that because there are so many illiterate persons. Those
suppose somebody is given access, you can be given access to. 2 persons can be given access.
No, that they didn't. Only one person is eligible and permissible by the SBI per one machine. And I was giving service since a long period. It is for last 5 years I'm giving service. But due to some unknown reason, I could not satisfy that want of that particular agency. Maybe it happened. I have been terminated. But be that as it may, I should serve notice.
215 of daily list.
2215 of the monthly list.
Monthly list. Monthly list upgradations I am not permitting. See,
My lord,
today is
Some
16th.
protection I needed, my lord.
What type of protection? Till the matter is taken up, I cannot give any protection. General protection.
No, not that, but because
Then-
if somebody is engaged, then my matter will be infractuous.
Come up with an application in that case. Nothing can be done.
But if some privilege
No,
can
sorry.
be given.
My lord, I'm
Yes.
praying leave to file two urgent motions.
Yes.
My lord, matter relating to e-tender in the ICDS projects of Murshidabad, my lord. Last date of submission of the technical briefs is 30th January, my lord. So, my lord, fix any date before 30th January, my lord. Within that time, my lord, I'm going to serve and come back.
30th January is a long way. You are not permitted to file the tender.
And no, I have
The
allowed to
bid-
participate, but
Yes.
but before 30th January, my lord.
No, you have been allowed to participate.
Yes, ma'am.
Where is the problem?
If my lord, I have filed in the department, maybe the matter will be taken up before.
Why
30th.
do you want? Why are you filing the matter? What is the relief that you are claiming?
Two clauses, my lord.
Yes.
It's disturbing, my lord. In the bid, my lord, take registered distributor. They are relaxing the clause of the registered distributor. My
They
lord.
cannot do it.
No, my lord.
Why not?
I am challenging that part. My
And you participating in the tender
Yes.
as well as challenging. I filed it in the department. I'm not accepting.
Okay.
Yes.
My lord, the money has been deducted from the petitioner's account by
Where
the
is
bank.
your matter?
My lord, monthly list, my lord.
Come next month.
I mentioned with your lordship's permission, your lordship, item number 281 of your lordship's monthly list. I am praying for non-prosecution, your lordship, for upgradation.
281.
281 of your monthly list.
You want non-prosecution.
Yes, my lord.
Why?
My lord, we had filed the writ on basis of section 14, that the order was not being passed by the DM under section 14 of the Surfacey Act.
Now
And
it has
during-
been passed.
Yes, my lord. Therefore, my writ becomes infructuous.
Tomorrow to be mentioned.
Much
My lord,
obliged.
may I permit to mention one matter for a content application for inclusion in the list?
Come next month, please.
Sorry, ma'am.
Come next month.
Yes.
Lordship, I'm mentioning for non-prosecution of 5 matters. In settlement has been made
Where are the matters?
in the bank-related matters. It is in the daily.
Lord, bank has taken bank loan, my lord. I already settled this matter. I want to
Where are the matters?
matter not list matter.
Not listed. Very well, give.
Uh,
Yes, call the list.
Lordship, may I be permitted to mention a matter for upgradation of the monthly list, Lordship? It's a very urgent matter.
Yes. But I appear for the
Lord, I
What the?
respondent,
Hmm.
private respondent.
Lord, I am appearing for the
Private
petitioner in this matter.
respondents. The state.
Your Lordship, I am appearing on behalf of the state, Your Lordship, may I appear virtually?
Yes, yes.
Yeah, Your Lordship, I have received the brief last night only. It pertains to a section 14 application which has to be disposed of by the district magistrate. If Your Lordship is kind enough to give me some time to get the instructions, next week, any day, I can get the instructions and I can assist Your Lordship.
When was the
The hearing-
application made?
The application was made in October 2022. My lord, the hearing was held. But may I take your lordship, my lord, the notice of hearing was issued. My lord, and if your lordship, my lord, kindly comes to page 55 of my petition. It's annexure P4.
Yes.
Where the hearing was held on 22nd of March. Thereafter, my lord, the hearing has been concluded. The order is awaited. But I have, my lord, issued a reminder. My lord, no order has been passed yet, my lord.
May I?
Yes.
I have,
Got the
I have-
borrower.
yes, I have two submissions to make. First of all, my lord, if your lordship kindly takes pain, my lord, to turn the section 14 of this act, my lord.
You are respondent. Which respondent are you representing? 3, 4,
Three,
5, and
three,
6.
three, three,
Three.
three,
4, 5, and 6.
three, sorry, 3 to 6.
All. The 4 is the director. Who is 5?
Mortgager,
Mort,
one of the mortgagers,
one of the mortgages.
Mortgagers. And 6 is also the other mortgager.
alleged mortgage.
Yes.
Yes, my lord, I have two submissions to make. First, my lord, kindly takes pain to turn section 14.
Yes, please.
Section 14, my lord, my learned friend has fairly submitted that, my lord, the application was filed before the DM, my lord, on, my lord, in the year 2022. Page 43, my lord, of the brief. Section 14, my lord, may I take my lords to the proviso clause. The other points are not I'm taking, I will take afterwards. Provided further that on receipt of the affidavit from the authorized officer, the district magistrate or the chief metropolitan magistrate, as the case may be, shall, after satisfying the contents of the affidavit, pass suitable orders for the purpose of taking possession of the secured asset within a period of 30 days from the date of application. Provided also that if no order is passed by the chief metropolitan magistrate or district magistrate within the said period of 30 days, for reasons beyond his control, he may, after recording reasons in writing for the same, pass the order within such further period, but not exceeding in aggregate 60 days. Provided also, after the requirement of filing affidavit, first proviso, but I stop here, 60 days. So the mandate of the statute is, the 60 days, 30 days first, then 30 days. So, the position of law, administrative capacity, even if we assume, he has become a functus officio, number one. Number two, the section 14, the judgment, in this, upon this code, R.D. Jain Company versus Capital First Limited, 2023, 1 Supreme Court cases, page 675, and paragraph 23. 24, sorry. As mandated by section 14 of the Surfacey Act, the CMM-DMM has to act within the stipulated time limit and pass a suitable order for the purpose of taking possession of the secured assets within a period of 30 days from the date of application, which can be extended for such further period, but not exceeding in the aggregate 60 days. Thus, the powers exercised by the CMDM is a ministerial act. He cannot brook delay. Time is of the essence. This is the spirit of the special enactment. Then,
which portion?
Para 32. 24, sorry.
24.
Para 32.
Yes.
Then, kindly comes to 32, paragraph.
Yes.
32 says, it cannot be disputed that the litigation under the Surfacey Act and proceedings under application under section 14 of the Surfacey Act are increasing. Even as noticed by the High Court in impugned judgment and order dated such and such, case 926 cases are pending under section 14 of the Surfacey Act before only one CMM. Therefore, a number of applications on section 41 pending. It also cannot be disputed that the Surfacey Act provides for expeditious disposal of the application filed under section 14 of the Surfacey Act. As per second proviso to section 14, suitable orders for the purpose of taking possession of the secured assets are required to be passed within maximum period of 60 days from the date of application, not otherwise. So, another judgment, 23, 1 SCC page 662, para 16. My lord has got it. Para 16.
Yes.
The statutory obligation enjoined upon the CMDM is to immediately move into action after receipt of the written application under such and such of the Surfacey Act from the secured creditor for that purpose. As soon as such an application is received, the CMMDM is expected to pass an order after verification of compliance of all formalities by the secured creditor referred to in the proviso in section 14 of the Surfacey Act. After being satisfied in that regard to take possession of the secured assets and documents relating thereto and to forward the same to the secured creditor at the earliest opportunity, as observed and held by this court such and such, the aforesaid act is a ministerial act. It cannot brook delay. Time is of the essence. This is the spirit of the special enactment. And then, the R.D. Jain, which I have referred, just now, that has been considered. Now, these are application, page 35 also, 43, of your lordship's brief. This is only for the purpose of showing, my lord, that this was filed on 43. That is 14/10/2022. In this type of cases, bank normally pursues like a private litigant, although an authority under Article 12. Now, kindly turns page 35 of my brief. Point number 2, why I am seeking my lord's kind undivided attention to this, 35 Roman 6. Banker answer to work. I have made a specific averment, in the petition that section 331I of the Surfacey Act envisages a salutary bar upon the secure credit from taking any steps in respect of agricultural land under the Surfacey Act 2002, considering the schedule of the properties which you allege to be your security, the following properties are shally or agricultural. My lord, these three properties I have enumerated, my lord, in the list. I will not take my lord's public, and also the subject matter of, my lord, the Surfacey Act, my lord, be pending before the section 14. Now, my lord, this answer, the response of the bank, my lord, is page 40. That in reply to your para Roman 6, which I have just shown to my lord, nature of classification is absent in the said NPA notice. We have to state that your account has been classified and such guidelines of the RBI. There is nothing illegality in declaring your account as NPA, hence your claim is not enabled. In view of all this such and such, my lord, my claim has been rejected. Now, my lord, I request your lordship, my lord, with humility, my lord, kindly comes to Rule 3A of the Surfacey Rules, my lord, 2002. Rule 3A.
Why will the court go into all these
No,
things at this
my lord,
stage?
yes, absolutely, absolutely, my lord. Before that, my lord, I can pursue my lord judicial conscience by saying, my lord, there are two types of jurisdiction in these administrative. Ministerial act, my lord. One is adversarial, that is we are fighting with the Korean combat, and the second is inquisitorial jurisdiction. The ministerial act, my lord, the performs under a statute, my lord. He, although section 14, my lord, the point of limitation, and also, my lord, the point not of the jurisdiction, my lord, kindly signs takes pain, my lord, to section 14. Why I say so, my lord? The Supreme Court, my lord, decided the law that it has become a functus officio. My lord, first of all, 14, my lord, 2, Roman 2. May I take 1 Roman 2? The first, provided that any application by the secured creditor shall be accompanied such and such, the borrower has created a security interest over properties and the bank or finance has valid and a subsisting security interest over such property and the claim of the bank or financial interest within the limitation period. So, my lord, limitation is an issue which could have been, my lord, considered by the DM within the statutory period 60 days, not beyond that, number one. Number two, my lord, that the finding of the, my lord, the finding is, my lord, certain, not uncertain, that it has to be the security interest which is executable. That means, my lord, it can be auctioned. Now, my lord, admittedly, my lord, the ROR which was submitted before the DM in response to his affidavit, my lord, should have been considered within 60 days. All this point. Now, this is a point of law I am urging before your lordship, kindly decides the issue that in view of these two judgments, section 14, interpreted by the Supreme Court under Article 141, will possibly under Article 144 says all civil and judicial authorities must come in aid of Supreme Court. In view of that, my lord, I request your lordship kindly decides the issue after 60 days in view of the Supreme Court judgment, whether the DM is authorized to decide in an inquisitorial jurisdiction as a ministerial act to decide all this question. This is a question of law. Permit me to come before your lordship with an affidavit. Will it only 3?
Nothing to affidavit. This is a
question of law. So
Where
let
is
the state say that he is authorized to do so.
Where is Mr. Dinda? He was there just now.
But I can make a submission, blood. So far as the bank is concerned, blood, we have taken out the application within time. The matter was before the district magistrate. It is a district magistrate blood discretion to dispose of the matter within a
Not discretion.
No,
It is
stipulation of
with
the act. That has not been done. All the more reason, blood, there should be a direction upon the district magistrate so that the matter can be disposed of. And kindly see, blood, the amount of money which is involved here is a 46 crore, blood, which is due
What
to
were
the
you
bank.
doing from 22 till 2025?
No, we have been pursuing this matter, blood. I have,
Where?
blood, I have annexed,
Pursuing,
blood.
there is a time limit to pursue. This
Yes.
is what you find out judgments where since there is no default clause, what is going to happen? Suppose the application is not disposed of within the period of 60 days. What is going to happen? Find out. And in the meantime, let Mr. Dinda take steps. Please come.
Your lordship is taking up the matter next.
Let's see. Mr. Dinda, he has left. Ashwini?
Can we get Miller 10 or 14 days?
Yes, yes. You can get.
Because I need his assistance, Miller. His cerebral assistance.
The writ petition has been filed by the bank alleging inaction on the part of the district magistrate, HON'BLE, in taking steps under Section 14 of the Surfacey Act. Stop. Learned advocate representing the respondent numbers 3 to 6 raises an issue of limitation. Stop. Section 14 of the Surfacey Act has been placed before this court. Stop. It has been submitted that the time limit within which the DM could have taken steps under Section 14 is 60 days. Stop. Beyond the said period, the district magistrate becomes functus officio and cannot take steps in the matter. Stop. The private respondents rely upon the decision of the Honorable Supreme Court in the matter of R.D. Jain and Company versus Capital First Limited and others. Reported in 2023, 1 SCC 675. And the decision in the matter of Balkrishna Rama Tarle, dead through legal representatives and another, versus Phoenix Arc Private Limited and others. Reported in 2023, 1 SCC 662. Stop. Paragraph. Learned advocate representing the state respondent seeks time to take instruction in the matter. Let the matter appear in the list on 12th of February 2025. Learned advocate for the state shall come ready with proper instruction.
Deeply obliged.
Service is taken on record.
My lord, in this writ petition, I have challenged the action of the respondent bank in taking possession of my flat. Now, my lord, this is done under Surfacey, my lord. But the thing is, I am not a constituent of the bank. I have neither taken any loan, nor am I a guarantor. There is no privity of contract between the bank and me. I had purchased the property in the year 2012, August 2012. I don't live at the property at all times. I have got mutation in my name, electricity bills, corporation tax. In fact, I'm also paying the maintenance charges.
That means you purchased the property when it was mortgaged to the bank?
No, my lord. I had write to the bank. I write to the bank because a possession notice was affixed on the door. I write to the bank that this is the deed by which I have purchased.
For the bank.
My lord, bank was appearing.
Bank.
The bank had, my lord, appeared and they had also.
Bank. First of all, my lord, in this matter, with respectful submission, my lord, this court has no jurisdiction in pursuance of the 2023 1 BCR 644 because IDBI Bank is not the state.
It's a private bank.
It's a private bank, my lord. And secondly, my lord, if at all he has any grievance, Section 17 is there of Surfacey Act. For
that I am aware of. Yes.
Which says any person, including borrower and guarantor, then he should go there.
Why have you made KMC as a party?
My lord, because to show that I am also mutated the property, my lord, the property also stands in my name.
For that purpose, you will sue the KMC.
My lord, I thought KMC would be a necessary party because my lord, this will show that I am not only the owner, my lord.
You must be having documents with you.
I have enclosed everything. My lord, may I just complete the 2 lines, my lord? I wrote to the bank saying that on what basis are you saying that this is mortgage? Because somebody else's name is shown as a borrower in the possession notice. The bank does not disclose. Cryptic reply, my lord. The bank says this has been mortgaged by certain Mriganko Chakraborty. I, my lord, go and I find out the deed by which this Mriganko Chakraborty has become the alleged owner. I find out that the Mriganko Chakraborty's deed is of 2014, 2 years after, my lord, I had become the owner. And my deed, I have annexed both my deed as well as.
But then all these things cannot be gone into in the writ petition first. Second, IDBI, your primary allegation against this bank is a private bank.
My lord,
how can the writ petition
bank, my lord, IDBI bank was created under a statute, my lord. Thereafter, it has changed into company, my lord.
But then it's not an.
And as on date, my lord, LIC is the majority shareholder of the IDBI, my lord. I have got the share
Section 17 proceeding is also there. You can agitate all your grievance over there.
The first order by which an interim protection was granted to me my lord, but the period of limitation is gone, my lord, and I couldn't approach, my lord, because I am not a privity. I don't have privity.
Doesn't matter. Any person can approach under Section 17.
And my
of
lord,
the
that is why
Surfacey
I'm
Act.
saying, my lord, because the Section 17 starts with the word any person, my lord, I would humbly submit that if my lord is of the opinion that this is a private entity, my lord, this is discharging a public function, my lord. My lord, today my property has been suddenly
Even
taken
then,
away.
you can go before the
Kindly seize, my lord. I
tribunal and
have
get
written to
things.
them. My lord, I'll just indicate one more thing, my lord. I have
please
made
don't
respondent
indicate.
numbers 8 and 9 a party. Respondent number 8, my lord, is a developer, and respondent number 9 is the owner. Now, the 2014 deed, which my lord will find, same developer and owner has sold my property to someone else after 2 years, and who has created mortgage, my lord.
Very good reason to file a civil suit.
My lord, civil suit will again be same point will be taken, my lord. That is the
Yes.
barred under Section 31, my
Please
lord.
come.
My lord, then kindly grants me a liberty to file suit, my lord, because again they will take the point
No
that Section
liberty.
31 it is barred.
My
My lord, will
the
kindly
petitioner is
consider a couple
aggrieved
of
by
judgments.
certain action taken by IDBI Bank Limited under the provisions of the Surfacey Act.
Private bank, 12% public duty tax.
Stop. Learned advocate representing the bank raises a preliminary objection with regard to the maintainability of the writ petition. Stop. Paragraph. The court is of the opinion that it will be open for the petitioner to approach the Debts Recovery Tribunal for redressal of her grievances in accordance with law, if so advised.
My lord, I will only pray for one indulgence, my lord. If the bank takes further actions under Surfacey, my lord, met that my copy of that notice be given to me, my lord, because it will be given to
If
somebody
this
else.
court is not entertaining the writ petition, then how can this order be passed?
My lord, only for issuance of notice, my lord. I'm not seeking any relief.
No, no.
Because I will be completely in the dark. Bank will go on publishing notices, my lord.
Nothing
I will not
doing.
know.
Yes. Dismissed. Dismissed.
Oblige, my lord. Highly oblige.
Interim order.
My lord, may I be permitted to mention under
This is not the
extreme
time to
urgency, my lord?
This is not the time to mention. I took
My
mention
lord,
half an hour back.
filing number. Yes, my lord. Filing number has been generated.
Yes, item 1.
My lord, this has come at my instance, my lord.
But without any notice to us, unfortunately, my lord, this was a very hotly contested matter, if your lordship recalls. No one, my lord,
May I make my
no one has served any notice upon us. We are all taken aback. The matter is straight away appearing in the list.
Now, my lord,
Yes, my lord, is not the answer to that.
But if he doesn't allow me to speak, my lord, this can't be taken. I am the petitioner, and both, my lord, I have to explain. My lord, so far as item number 2 is concerned, my lord, here is the mentioning notice, my lord, which was served, my lord, on them. And thereafter, the matter was mentioned.
Not served on us.
My lord, this is the notice.
It was not served on us at all.
Now, my lord, my lord, the order sheet.
The state did not receive. Mr. Ushanath Banerjee did not receive.
Yes.
It mentioned item number 2. My lord, on the previous occasion, my lord, both items had appeared together. So probably that is why, my lord, both matters have come up today, my lord, together. But my lord, we had mentioned only item number 2. And my lord, that is what, my lord, that was done on notice. And thereafter, my lord, subsequent email was.
Notice to all the parties?
My lord, 3 parties, my lord. Here is the notice.
Let me
Copy of
see.
the.
Let us have a look.
Anyway, what is your prayer?
Now, my lord, this matter relates to a fraud committed in course of registration. My lord, I am
Registration of?
A deed.
Of a deed.
By the registering authority. My lord, I'll just take 2 minutes, my lord, to give a conspectus to.
To be mentioned matter, 2 minutes is not given.
30 seconds, my lord. My lord, my property, my lord, X registers in favor of Y, my lord. And my lord, after the document is registered, my lord, we find that there has been interpolation in a registered document. My lord, we file a writ petition. And my lord, in that writ petition, we also point out that the properties mentioned in the document are, my lord, situated elsewhere than what has been mentioned in the query slip that was obtained. Now, my lord, all these issues were taken up for consideration. Direction for affidavits were given. Now, my lord, in the meantime, my lord, we had preferred an appeal from that order. My lord, when the appeal was pending, my lord, we got a document from the municipality certifying that the premises number mentioned in the deed is not within that municipality and the Moja is also different. So, my lord, we withdrew the appeal. Now, thereafter, we mentioned this matter because, my lord, affidavit directions were given, my lord, long ago, my lord, on 4th of September.
Affidavit has not been filed.
Not been filed. Now, my lord, a report was required to be filed by the state as to meet the challenges because, my lord,
That has also not
that
been
is nothing
filed.
has happened, my lord.
Yes.
The document stands as it is, my lord. So,
Hey.
by the registering authority is
So
concerned.
today we are only concerned with the affidavit and the
My lord,
report which has not been
I
filed.
was beseeching a date of hearing, my lord, if they want to file affidavit, because, my lord, a report from the state, the registering
Let me
authority
see.
is.
Item number 2, who is for the state? Shayan Ganguly, notice was given to you? Yes. So the submission that notice was not given is not correct. Please wait. Where is your report? So you do not intend, your clients do not intend to file any report. How long will you take time? Because see, the petitioners are pressing for hearing. The court has given you time. And if your clients do not intend to file a report, then don't file. We'll proceed on the basis of the documents which are already on record.
Because, my lord, in
Do you get it? You are for the state. And who is the other party from which the affidavit or something has to come?
my lord, Miss Sucheta Banerjee's name appears in the last order, my lord. We have served her.
Appearing
My
for
lord, respondent number 7.
Who is the respondent number 7?
My lord, Regent Vinimay, who is a beneficiary of that fraudulent document.
No, we are Regent Vinimay. We are Regent Vinimay.
Who is your advocate in record? Sucheta Banerjee?
My lord, the order sheet records her name.
Fox and Mandal. I do not know, my lord, how Sucheta Banerjee can be representing us. No,
the order
he's not
sheet
acting for us.
My lord, kindly has a look at the order of 4th September in item number 2.
That may have been a mistake. They are aware there are multifarious writ petitions pending. They are multifarious writ petitions.
The party.
Regent
Vinimay,
the beneficiary of the fraudulent document.
Represented by Fox and Mandal.
Affidavit.
We've never been told that the matter will be coming up.
No, my lord, direction. Yes.
There is no question of telling somebody. There is
file
an
an
order.
affidavit. Yes. We have not filed an affidavit till now.
Don't wish to.
Yes, we do.
Then why did you not file it? The time has expired.
We do, my lord. Kindly permit us, my lord. Give an extension, my lord, so that we can file an affidavit. Please.
Why? As a matter of course.
No. We are making a prayer. We are making a prayer. If today they would have put us on notice that they were trying to mention the matter today.
Suppose.
Yes.
The mentioning notice was not given. Time to file the affidavit has expired.
Yes.
Then what is your answer to this?
My lord, my humble prayer is a lot of events have happened even after the direction was made.
File an affidavit and disclose everything.
Yes, we'll do that.
If you choose not to file, then we'll proceed.
My lord, almost every day subsequent events are taking place.
So
this is not an alibi for not filing an affidavit. No, please don't take me amiss.
Then
I kindly grant me a liberty, my lord, to file an affidavit within the shortest time your lordship will extend.
And at the very first moment, you keep shouting, notice has not been given.
Notice has not been given. I still, my lord, notice has not been given is something, my lord, which I am still submitting.
Somebody was mentioning for filing affidavit.
I appeal for respondent number 6.
Yes.
I have not filed my evidence. You can extension.
কাটিবাজি নারদবাজি কাটিবাজি আলাদা করে টাকা দেয় সারদা বলে 3 টাকা আলাদা করে দেয় নারদবাজি করবার জন্য
So all they have come on affidavit.
নারদবাজি করবার
Whatever is there, please do.
আলাদা করে 20 টাকা দিয়ে
Direction is already there.
I apologize for that. Then I find that. Let's put this on effect.
Who are the other parties from whom affidavit is required to be filed?
My lord, the state authorities are 1 to 5.
1 to 5.
7.
6, 7. Nobody else. Please come. Neither the affidavit in opposition nor the report to be filed by the respondents have been filed till date. Stop. Prayer has been made by the learned counsels representing the respective respondents for extension of time for filing the affidavit/report. Stop. Next. On such prayer, time to file the affidavit/report is extended till 6th of February 2025. Reply, if any, by 20th February. Liberty to mention the matter for hearing upon notice to all the
I was
parties.
teaching, a date is given, then the affidavits will come. Otherwise,
If the date is not given, the affidavit will not come.
so, may I, I was only beseeching a date, if
No, date cannot be given.
Obliged, Your Lordship.
Who are you? Is the
in
June
the item one has not been mentioned, Milord.
Item 1 has come.
Item number
I'm being
1
led by
has
Mr.
come automatically because item number 1 was tagged along with item number 2.
You do not want
He
any.
did not mention item number 1.
Yes.
Let there be direction,
My
Milord,
lord,
for
only
affidavits
one
there.
there. My lord, Lordship has been pleased to direct the state to file affidavit. Give us a date, any day, any subject. Your lordship.
Date within which affidavit has to be filed is mentioned.
No, my lord.
The returnable
Matter to be posted on some day. Matter may be posted. Kindly give us a date, some date, my lord, subject to it. I think everybody would like my lord, to this, my lord, nobody has it. What, my lord, kindly, my lord, may I?
My lord was looking as somber as possible, then my lord burst into laughter.
My lord, may I?
Cannot.
My lord, only one prayer. My lord, I think this will not be opposed. My lord, once the date, my lord, your lordship has given an outer date for filing of affidavit. My lord, kindly post the
Once it is over,
my lord, let it appears to be mentioned on some other date.
excuse.
And after this, I cannot make. My lord, subject to my lord, whatever my learned friend would submit. I think these two matters may be detached.
No, no, why? Let them stay together.
My lord, led by Mr. Usha.
No, if they have been tagged earlier, my lord, if they have been, my lord, if they have been tagged earlier, there has to be a reason for their
My lord, the issues are different. My lord, that Mr. Banerjee would agree.
They are tagged. If they have been tagged together, why?
You are for the petitioner.
Yes.
You want it to be detagged.
Yes.
Very well, detagged.
Yes.
No, tagging by an order. It was tagged by an order, my lord. My lord.
There is no order.
In item number 1.
Yes.
Please record your appearance. Learned senior counsel representing the petitioners. In the writ petition numbers, দুটো নম্বরই দিয়ে দেবেন। WPA number such and such and such. Submits that the that the cause of action for filing the writ petitions are different. Stop. Prayer has been made for detagging the writ petitions. In view of such submission, let both the writ petitions be detagged. So what is going to happen to item number 1?
Well, item number 1, we are seeking de-tracking where your lordship has been pleased to pass an order for filing of affidavit right now.
No, this is item number 2.
Item
number 1.
I'm kindly pass an order for filing of affidavits.
Well,
We can
item
come.
number 1.
Yes, let it come separately. Now, one to kichu chilo na. One affidavit direction chilo na.
Only in item number 2
I'm
it
sorry,
was mentioned for affidavit 1.
Yes, but I'm
There
sorry.
was
Item
one-
number 2.
One, my lord, there was no direction for affidavits.
Yes.
I'm humbly submitting since your lordship is detagging it. It's all right, no difficulty.
No,
But today, my lord, kindly, my lord, issue directions for affidavits there as well. If when the matter comes up, when the matter comes up in March, let all affidavits
May I just humbly submit before your lordship, subject to whatever Mr. Banerjee would submit. My lord, item number 2, item number 1 was taken up by your lordship prior to vacation. But that was that noisy hearing.
All hearings are nice.
My lord, your lordship may recollect. So, my lord, your lordship has been pleased to pass an order that certain directions were given and liberty was given to mention for hearing. So, it is at that
Without
stage.
without
Without
any
affidavits. Therefore, my lord, I am humbly
No,
submitting.
there is a prior direction for affidavit.
There is
Yeah, there is a subject to correction. Subject to correction by Mr. Banerjee.
Subject to correction by my learned senior friend, perhaps not.
No,
Because the order of 4th of September.
একটা দেখে নে
না হলে একটা affidavit ডিরেকশন করে নিচে আসুক
না সেটা অ্যাপ্লিকেশন ফাইল করব তারপরে করব না না তো অ্যাপ্লিকেশন টেক
My lord, may I just submit? There already is an direction for affidavit in that matter, subject to correction by my learned friend. My lord, kindly post this matter on any day within which whatever pleadings are there, my lord, that may be taken up. Because liberty to mention has been granted by your lordship. Affidavit হোক না, তুই কি আছে?
Well, let there be an extension, Lord. There is a direction. Now, I
Then,
tell you,
I'm
when the
correct.
matter came up before your lordship on the earlier occasion, my lord was pleased to, my lord, hear the parties and to make certain orders and make the matter.
Yes,
My lord,
yes.
thereafter give us liberty to mention for hearing.
The tagging order was there prior there too.
Yes.
Yes, yes.
So
It's not that this court
No.
passed order.
No,
for
no, no,
tagging.
no, 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 no.
It was there.
Yes.
Now it's your prayer, detag,
Detag, but I'm
And
now
today, since
making
the matter is
submission.
in the since the matter is there in the list,
My
today,
lord, I am
I am
making,
making a humble prayer, my lord. Kindly let the respondents exchange their affidavits.
but in respect to item number
Under
one.
one.
Item number
One
one.
affidavit.
Extension.
One করে দাও।
Extension.
আচ্ছা, extension.
Date গুলো same থাকবে item 1.
আরে আমাকে 759 এ নিয়ে গেল, মামলা ওখানে হয়ে গেল।
আজকে district court একসাথে এসেছে।
ইডি টাইপ
দুটোর একসাথে এটা আলাদা উপরে কস্টাডিটা একসাথে দিয়ে দিন আর মাঝখানে একটা ক্যাপশন করে আইটেম নাম্বার 2 এর প্রথম অর্ডারটা আর পরেরটা হচ্ছে আইটেম নাম্বার 1। হ্যাঁ হ্যাঁ ওয়ান এবারে ডিটাগিং এর অর্ডারটা দিয়ে দিন না 1 এর শেষে বা একদম গোড়ায় আচ্ছা সেটা কোথায় থাকে ওখানেতে শুধু ওই এফিডেভিটের ডিরেকশনটা যে যাচ্ছে এফিডেভিটের ডিরেকশনটা তো থাকে হ্যাঁ সেই একই টাইম মানেতেও করে দিন সেম
বলছি না
ডিজিট একটা একসাথেই হবে কমন অর্ডার হবে সেখানে একদম গোড়াতে দিয়ে দেবেন
কত দিয়েছিল কত সে
My lord, only thing, my lord, in item number 1, my lord, the record was already placed before the court.
ঠিক
On
আছে
the
তুমি
scheduled
বলাই
date
কি
when
দরকার
the affidavit
so from the state nothing is wanting
for respondent number 15 to 17, my lord, the labor department. State is also another party.
who is appearing for this state you do not appear who is appearing for this
মানে
state
Mr. Ushanath Banerjee was appearing for
Mr. Devanshu Dinda.
Mr. Devanshu Dinda.
You've not given notice because it was not meant.
But Mala, I have to be candid before Lordship. Since we mentioned that item number 2 before Lordship, no notice was given with respect to item number 1.
দুটোও দেয়
তাহলে আইটেম নাম্বার
Pilot has given it
1
to
তে
us six.
একটা লাইন অ্যাড আপ হবে যে let this order be communicated to the learned advocates representing the respective parties item number 1 এতে
এটা কত 6 আর কত দিয়েছে 6 কত ওটা 6 আর 6 করে
1 এতে স্টেট আসেনি তো
my lord, only one prayer ahead.
আচ্ছা
Sorry.
I have a appearance slip over here which mentions the name of Mr. Shamrat Sen. He is not here. Bishwabhrata Broshomallik, he is not here. Wasim Akram, I do not know.
Wasim Akram.
Ahmed. Wasim Akram is
Wasim Akram has now retired.
he has retired.
Not there.
Wasim Akram was that fast bowler, my lord.
Left hand fast bowler. Oh, that is Wasim Ahmed.
Wasim Ahmed, I think.
It's written Akram.
আকরাম লিখেছে
Akram লিখেছে।
ওয়াসিম
I
আকরাম
don't
লিখেছে
know whether somebody by that name is here or not. Devanshu Dinda, none of them are present. And item numbers 1 and 2.
My lord, I'm
Just imagine how the appearances goes wrong. And it is not possible for
yes,
the
yes, yes.
court
Not
to
neither the court
find
nor
out
the officers. Yes.
and check who is appearing.
It does not go well for the state too.
Absolutely.
Because if elections are passed against the state and if appearances are noted, they cannot.
And more particularly when the live streaming is going on.
Yes.
Everyday councils come and say, my name is not there, my name is here, I did not appear, I appeared. These problems come up.
No, it's
And
not
see if this slip, somebody handed over this slip, I don't know who. Because number 2 state is here, his name Unar namta esche.
All we know that Mr. Banerjee was appearing for the labor department.
Labor department. He is leading me.
For the state, my lord, both the matters I am appearing for respondent number 6, my lord.
Anybody who is not appearing, please don't hand over names by this, in this manner. Anybody who is not appearing.
Item number 1, my lord.
Don't give. Anybody who is present here, please give your name, no difficulty. But then anybody who is not here, then please not give the names.
For respondent number 6, my lord.
Please give in both the matters.
First matter. Second matter, municipality is not a party.
Municipality is not a party only.
Please write down the respondent. Then it is all right. Item number and the respondent. So many slips have come over here. And most of them are not here.
My lord, we had only one prayer, my lord. Only one prayer, my lord. Lordship has made it 6th and 20th. 6th and 20th. There are a number of events that have taken place, Lord. Would it be a week more? A week more.
They are pressing for hearing.
That's all right. 13th and 27th.
My lord, then, my lord, I do not oppose, but let it be parented.
না তা ঠিক আছে অসুবিধা পেরেন্টরি না করে আর একটা সপ্তাহ চাইছি দাদা
না না আমি ওইটা এক সপ্তাহ দিয়ে বলছি পেরেন্টেড
অপোজিশনের ডেটটা চেঞ্জ হবে
ওটা 13 হয়ে গেল
ওরা 6 তারিখে করেছিল
দেন মানে 30 27 পেরেন্টারি
21st করে দিন 14th and 21st 21st না ওটা 28th করে দিন 28 14 28 liberty to mention in both places.
ডিপলি অবলাইজড নাম দিয়েছো যারা আছেন তাদের নাম দিয়েছো
এগিয়ে যাচ্ছে অপমান করবে
যারা এখানে আছে তাদের দাদা item number 2 যেটা আছে না সেটা কস্ট টাইটেলটা দেখে নাও Chief, I'm for the petitioner.
Number 8.
I have filed an application for addition of party.
To be mentioned কেন
Yes.
Lord, I beg to for the respondent number 8, Lordship.
Lordship.
Matter was dismissed yesterday, Lordship.
all right
Lordship, this is
I applied for the statement.
you were there yesterday the matters to dismiss
yes, Your
because of
Lordship. Item number
non-appearance of
121, Your Lordship would remember.
the learned advocate, but then he was there online and he could not join.
Yes,
This
Your
is your
Lordship.
submission.
Yes, Your Lordship.
So what is your prayer?
Your Lordship, this affidavit of service may be recorded. This is the matter.
I have filed an application for addition of party in this matter, my lord.
I have not been served properly, Your Lordship. I have got one
I have-
mail. I have got one mail, but the hot copy has not yet been
He
served.
said that he is served on mail. I am served on mail. He requested to serve mail. Mail বলেছিলেন।
Hard
Yes,
copy.
what is your submission?
Yes, Your Lordship. This is a matter
I
regarding
have a hard copy here in now.
regarding Khutia Gokulpur Vivekananda Vidyapit.
Hard copy
The
I
petition.
have given hard here now.
Obliged. Lordship, kindly request that I want to file an opposition to this, Your Lordship.
Tell me what
Yes.
you have got to
One RTI application was filed, Your Lordship, and after that, first appeal was filed, second appeal was been filed, and the teacher in charge, who was the custodian of the information, was regularly directed to provide the proper information. The information was the managing committee report adopted on 12/10/2018. The RTI application was filed on 25/1/2023, Your Lordship, but in spite of regular directions by the district inspectors of school, the respondent number 6, and also the deputy secretary academics, SPIO of the West Bengal Board of Secondary Education, respondent number 5, the teacher in charge, he's standing in strict violation of those orders and not providing me the proper documents, Your Lordship.
Did you make the SPIO a party?
Yes, Your Lordship.
Deputy Secretary, he is not giving the information.
No, Your Lordship. The teacher in charge, he is the
Yes.
custodian of the information, Your Lordship.
TIC. Respondent number 10. Anybody there? Who are you?
No,
Who
my lord,
are
I am from ex-teacher in charge. My lord, in which, my lord,
You are
ex-teacher in charge.
ex-teacher in
Ex-teacher in
charge.
charge. Because in my my lord, tenure, my lord, some records has been, my lord, taken by my learned friend's client, my lord. He has returned the same. I lodged FIR. The criminal case is going on. The all records are, my lord, lying in the, my lord, in the criminal case. My lord, he is not appearing in the suit.
Yes, Your
criminal case. As a, my lord, my lord, if he, my lord, appeared in the criminal case, my lord, he will get everything.
Lordship.
And criminal case is pending against him, my lord, for taking so many records of the school, my lord. When he was, my lord, conducting the, my lord, as bridge between the school and the DI office. He has taken all the records in the bag.
Bridge between the DI office and the school. What is his designation?
I bow down to your lordship, but I would like to refer to your lordship that the criminal case that they have been referring to, one FIR was lodged. After that, I was given FRMA. After that, they have filed one Naraji petition, which they have strictly suppressed in this application. Here is a certified copy, your lordship. I have just got them some minutes back. I have given FRMA. They have applied for one Naraji petition, which was again dismissed. So these are the things that has been suppressed in their application, your lordship. What they are doing is from 2023, they are not providing me the proper document.
Who are you?
I'm the petitioner, your lordship. I'm the assistant teachers. I'm the assistant teacher and one of the member of the teachers representative government sponsored managing committee of that school, your lordship.
Now he is not there. He has transferred from that school.
No, but during that point of time, I was the assistant teacher, your lordship, and the whole matter regarding that particular cause of action is still pending, your lordship.
See, now the allegation is, according to the TIC, you took away the documents. You say no, the documents are there in the school. They are not providing it. What will the commission do? Commission doesn't have, the SPIO doesn't have the records. If the records are not there, then what can be done?
Your lordship, the records are to be there. According to, your lordship kindly comes to mind.
This is the thing, that the record should be there, but you have taken away those records illegally, and that is the reason a criminal proceeding is
No, your lordship.
you. Maybe the criminal proceeding has since been dismissed. Everything is there, but if the records are unavailable, then it has to be reconstructed or something.
Lordship, kindly
Otherwise, how can the deduction be passed?
Lordship, they are particularly hiding those records because there had been one tampering of those records by the ex-teacher in charge, your lordship.
How do you know that there has been tampering? You have documents?
Your lordship, if I get the document, I will be able to prove that there has been tampering with those documents, your lordship. That's why I'm seeking for those.
Without going through the document, you know there has been tampering?
Lordship, I have seen that document.
You must be having documents with you.
No, your lordship, at that point of time, I was made aware that there has been some kind of discrepancies, which I'm not particularly sure about it. But your lordship, I will get the evidence once I get these documents, and the custodian of the documents is the teacher in charge, your lordship. Kindly, your lordship, let me file an opposition to this. Can your lordship, if they want to be?
What is the use of filing opposition to the intervention application? You have to succeed on the merits of the case.
Yes, your lordship.
Suppose that intervention application is not there. What is going to happen?
Your lordship, at that point of time, the teacher in charge, that is Mr. Ojha. Yes, Chandan Kumar Ojha. He will be held that he is the custodian of those documents, your lordship. Now, what I can press for is to get those documents from the custodian of those documents, which is again reiterated in Annexure P5, starting from Annexure P5.
You are the school. You are the.
He's for this.
I am not for this. I am for the respondent number 10. Respondent number 10.
TIC.
Present teacher in charge.
Present teacher in charge.
He has joined in the school in the year 2020.
All right.
The document is for year 2018.
All right.
Prior to my appointment in that school, his client was appointed in that school.
Right. So you say you do not have anything, but then the records, suppose you have joined later on, the record should say, it's not that a teacher in charge goes and the records goes with him or her.
May I suggest before you?
Yes.
Your lordships kindly direct managing committee of the school, because it's a government sponsored institution. Managing committee of the school, if there is any 2018 document resolution is there, then if any there, if your lordships kindly direct the managing committee of the school to take a decision as regards furnish those document to the petitioner through teacher in charge, present teacher in charge. The custodian.
You are the current teacher in charge.
Fine.
You must be knowing whether the managing committee, whether these documents are there or not. And if the erstwhile teacher in charge has filed an FIR stating that these documents are missing, then how will the managing committee get these documents?
The intervention application has not served upon me.
That is all right. That may be served. But then the submission is that those documents are lost or taken away by the petitioner.
Yes.
Since 2016,
That is
Lord,
to be ascertained.
all the acts are done by
State, who is there? You are for the state. What can be the way out?
In respect of the, my lord, applying of the documents, my lord, we have already kindly come to, my lord, page 79 and 80, my lord.
You have requested for supplying these documents.
Yes, my lord.
Yes.
Now these documents
Are lying in the custody of the school, my lord.
school.
In the custody of the DI, there is nothing, my lord. We have requested the school to supply the documents. Page 79 and 80.
No, that the petitioner admits that there is a direction for supplying the documents, but the person who held those documents says that these documents have been taken away by the petitioner.
Since 2016, page 13, I have, Lord, the resolution is there.
16, Your Lordship, they have been praying that
16,
it was
Lord,
their
there-
submission that I joined the school in 2020, Your Lordship.
The petitioner joined school in 2020.
No, 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 no.
That's what they submitted minutes.
Present teacher in charge joined. Present teacher in charge joined in 2020.
20.
And since when is the petitioner there in the school? For a long time.
Yes, Your Lordship.
Before 2016, before
2016, Your Lordship.
if you want to be headmaster of the school, Lord, for the reason one headmaster came, Lord, for long days, Lord, there is no headmaster. Long headmaster came, taking his, Lord, he is not willing to join the school. He has taken that documents from him, Lord, forcefully, but he is not handing over the same. His intention was to be the headmaster of the school. Lord, I have the resolutions are there. All records are there. Lord, you will also maybe please to see the resolution, Lord, page 16. What is there?
Page 16 of the
Of the addition of pre-application.
Then in that case, let them file opposition. Let us see. I do not know how the resolution can be made. Please come. An application for addition of party has been filed by the erstwhile teacher in charge of the subject school. Stop. Let copy of the same be circulated.
Hand it over. Hand it over.
Stop.
Lord, I have given. I have given.
Learned advocate for the petitioner seeks time to file opposition to the same. Let opposition be filed within a period of
Lordship, 14 days.
3 weeks. Reply if any.
Lordship, actually, I am in need of the documents as soon as possible. I will be
then 2
obliged.
weeks. 2 weeks. Reply if any within a week thereafter. Stop. List the matter on 20th of February 20.
Lordship, may I ask for a week earlier, Your Lordship? May I ask for a week earlier, Your Lordship, at least? In the second week of February, any day?
13th.
I'm obliged.
13th of February.
Grateful, Lordship.
Affidavit of service may be.
Mentioned it, it should come as
Petition to be filed.
adjourned motion.
Lordship, the affidavit of service may be taken on record.
Yes, service is taken on record.
Affidavit of affidavit of opposition to the addition of party.
To the addition of party.
Yes.
In the meantime, state, please take instruction with regard to the existence of these documents. একটা লাইন লিখে নিন তো, learned advocate for the state shall take instruction with regard to the documents sought for by the petitioner under the Right to Information Act.
Good.
Grateful, Lordship.
I'm grateful, Your Lordship.
Documents lying in the office of the DI.
No, that I know. From the school.
Your Lordship, I am for the petitioner, Your Lordship.
This is a customs matter, my lord. This is group 4.
Why I am saying it's not group 4, Your Lordship. I am not the subject matter of this petition does not relate to any revenue, Your Lordship. I have made an application for compounding of the offense.
Under the Customs Act.
Yes. Offense has been
Under the
initiated
Customs Act.
Your
Let
Lordship.
it go to group 4. Please come.
But Your Lordship, that the compounding of offense, that application has been rejected, Your Lordship.
So the group 4 bench cannot take it up. Acha. Let the matter be released from the list for want of determination and be placed before the bench having determination to take up Group 4 matters.
Wait for me.
The petitioner is not here. Has the child been handed over to the mother?
My child is in my custody. Madam.
So the writ petition has served its purpose. Please come. Yes, please.
In view of the fact that the and the mother were foreigners and Bangladeshi were arrested, and the Supreme Court has said there are 5 written judgments. Question of they are accused and criminal charge is pending. They cannot leave India without the permission of the civil authority.
I'm not leaving.
That kindly, Lordship will kindly record that.
It is a direction of the SCJ.
1 minute. Yes.
The Lordship has seen the report of the last occasion.
Yes, for repatriation.
Yes.
Yes.
That cannot be done now.
All right. Please give. Please give. Learned advocate representing the petitioner and the state respondents submits that in compliance of the order passed by this court, the petitioner, that is the minor son of the Bangladeshi citizen Rupa Das, has been handed over to his mother. Stop. The communication dated 11th of January 2025 by the Superintendent, Nodia District Children Home for Boys be written with the records. Stop. The learned ASGI points out to the direction passed by the Honorable Supreme Court on 6th January 2025 in Criminal Appeal number 2814-2815 of 2024 in the matter of Frank Vitas versus Narcotics Control Bureau and others. Paragraph 5. Wherein the court specified that once a foreigner is released on bail, he cannot leave India without the permission of the civil authority. Stop paragraph. In the instant case, the criminal proceeding against Rupa Das, the mother of the petitioner, is pending consideration before the learned trial court. Stop paragraph. The till when is the visa of this child there? Child's visa? What is the
Child visa
date?
was invalid when he was taken into the custody.
No, now it is still valid. The child's visa
No,
is valid.
child visa is not right now not valid.
Both expired,
No,
mother and the son?
Mother is still in existence, but not the son.
Mother's has expired.
No, mother will going to expire in the February.
Why was she arrested?
Not within his custody. Subsequently, I got the documents from the Bangladesh and I have shown, I released on bail on
But
that.
is there any proceeding against the son? Right now, no proceeding.
No proceedings. Only mother is, I guess, proceedings was there.
Acha. What is to be done in this case in favor?
Criminal court has already directed that
The mother.
required both the mother and the son be produced.
That is the order
That
of,
is the last order.
yes, page 67. And I have been furnished 50,000 bond for my son.
Very well. The petitioner and his mother shall strictly comply the order passed by the learned trial court in GR 720/2020. Which petition stands disposed of?
I'm grateful, Your Lordship.
My lord, I am for the petition. My
Yes.
affidavit of service.
Who is your other side?
Lord, I have served, but this is the first.
What is your prayer?
My lord, my prayer is twofold. One is renewal of my clinical establishment license, and for proper direction upon the respondents for proper investigation for harassment and damages. I have been.
When did your license expire?
My lord, the crux of the matter is the petitioner is a petitioner is a first class MSc degree holder in MSc zoology.
There are two petitioners.
There are two petitioners. Both of them have similar qualifications. They have been running a genetic laboratory since 1998. After obtaining CE license, clinical establishment license, as well as license under PCPNDT Act. Now, in 2018, the authorities, in spite of having no other predicament, have refused my license. They have refused to renew my license, though I have applied. Now, they have come up with the point that I am not qualified enough to continue with this genetic laboratory. Matter was sent to an expert committee where the opinion has been given that a geneticist can operate a genetic laboratory. The opinion is also here. Now, a writ was filed, direction was given to consider my prayer. Now, they have complied with the direction. Now they have rejected my application.
Show me the order of rejection.
My lord, it is at page 341. Seventh volume, last volume.
Yes, I got it. 341. Show me the earlier order, please, pursuant to which this was considered.
This was considered, my lord, till since 1999.
Show me the order of this court.
Of this court.
Pursuant to which this order has been passed.
Yes, my lord. That is at page 314.
314.
Annexure P37.
Yes. Is the Union of India also a party here?
Yes, my lord. Union of India is also a party.
What is the
Since-
role of the Union of India? It's
The
a central act.
PCP is under Union of India, not under the states.
Central act.
So this is a central act.
Hmm.
Because of the CE license not being renewed, my PCP entity license is also being kept on hold.
But then the CE license is to be issued by the state authorities.
Yes, my lord. CE license have to be issued by state authority, and actual fact remains, on the basis of this license, apart from the institution the petitioners are running, there are 3 PPP projects are running in rural hospitals, and and on the though being under the control of the local authority, that doesn't require a license under Clinical Establishment Act, but they have taken the plea that since my license is not renewed, my PPP projects will not be operated, cannot be operated. And my lord, due to the
Listen, you have been given liberty to file afresh for permission to run the lab.
Yes.
As per the requirement, and subsequent CE license will be issued or rejected based on the report of the inspecting authority. So you have been
inspection has already been done. Now there is I bow down to your lordship. The permission has been given for a fresh license. But obtaining a fresh license will cause me a discontinuation of my license, because last valid license was in 2018. Now, after that, since the CE license and PCP NDT license have been kept on hold, my client could not run this his institution. He is also a genetic consultant.
It has not been kept on hold. It was rejected long back.
I mean, due to the rejection.
Yes.
That was, I couldn't get that, but there is no formal objection or legal objection which they could have raised. Only problem is, if I am not getting a renewal of this, my continuation of the service will go.
How does it matter? If the continuation
it is a matter because I am running this PPP projects in 3 rural hospitals based on this license.
But then your license has expired in 2018. First is 2018. The laboratory license was valid till 10th of May 2018.
Yes, my lord. Now, my lord, the structure is like
and
this.
The same application was rejected for non-compliance of the criteria. How can there be a continuation if it was not renewed in 2018?
My lord, the structure is like this. Petitioner is running an institution and under the name and style of AIDC. Now, on the basis of that experience, 3 PPP projects were entered into with the respondents. Member Secretary.
See, the projects were entered into when you had valid license. Now, the moment your license expires, then you could not have continued with the projects.
No, my lord, because under CE license, under this act, CE license is not required for any clinical establishment maintained by or under the control of state government, central government, or local self-governing authority.
Now, 2018, this suppose it was not done. When did you file the earlier writ petition? In 2022.
2022.
What were you doing from 18 to 22?
Yes.
You did not take any steps.
No, I have been perusing. I have approached the higher authorities. They have there was a direction to for a medical report, which was sent to us.
The rescind order, Milord, it has been categorically mentioned, Milord, that they have insufficient of spaces, and not only that, Milord, there are other reasons also.
My lord, kindly consider annexure P8 at page 93, which is in volume 2.
বলে দিয়েছে জেনেটিক ল্যাবরেটরি লাইসেন্স দিয়ে
Inspection.
Did you make out a case on the earlier occasion that this license is not required?
Under PPP projects.
Where is, I have read the earlier order, nothing is mentioned over there.
No, that was, this is, this earlier order is regarding to AIDC, the institution of the petitioner. So under PPP project, that is a issue. That issue is being raised by the member secretary and CMOH, who are also the authorities under PCPNDT in this, under PCPNDT Act. Now taking advantage of the knowledge that my license is being withheld deliberately, they are obstructing my PPP projects since I don't have a license. Now Act is clear that under this, if I am running a project under the local government or local authorities, there is no requirement of a CE license. But they are taking the plea, they are harassing me. Since I don't have a license under PCPNDT and CE Act in AIDC, they won't let me run this.
But this is not the case that you have made out in the writ petition. Your writ
No,
petition
my
is
writ petition is in respect of CE
Right.
license in respect of AIDC.
Right.
And I require those license because that is my bread and butter.
But then the submission that you are making here, they are two different submissions and two separate causes of action. The earlier one, the PPP, is not a part of this writ petition. So the court cannot entertain your prayer.
No, that is, my lord, actually this is a intertwining problem.
Whatever thing is, page 341, the order passed by the CMOH HON'BLE is impugned over here. The PPP project certificate required or not required, license required, not required is not a cause of action over here. So the court is not here to adjudicate that. What is to be adjudicated is page 341, right? Now, 341, you have been given permission to make fresh application after complying with the formalities.
Yes, my lord.
You act accordingly. How are you aggrieved?
My lord, only problem is if since CMOH and member secretary of family health, they are common in this factor. If I obtain a fresh license, they will show me a discontinuation because they are deliberately
You are
doing that
going
in
back to
my
the same
PPP.
thing that you have not pleaded in your writ petition.
My lord, that has been pleaded, but since it is voluminous, I'll get some.
Maybe voluminous, but please show out what is the case made out over here.
My lord, bolben na ekdom. Kindly consider page 93.
Yes, page 93.
This is a report filed by Deputy Director of Health Service Administrative, West Bengal. When they have refused my license in 2018, I have made an application for renewal.
Page 93 is your appeal to the appellate authority. Reasoned order was passed prior to that.
Yes. Page 93, my lord, of volume 2. There is a report.
A report. Page 93 is not the report in my brief. Copy of the signed reasoned order. Page 93.
So annexure P8, my lord.
Is it the Commissioner Department of Health's document?
My lord, this is the
Yes, this is the letter that I am seeing.
now, sir, annexed to that is a report.
This is the conclusion. Lordship, kindly see the conclusion
One
part.
minute. Page 94 is a reasoned order in the wake of the appeal.
Yes. My lord, kindly come to point C at page 96. They have been
Point C.
They have refused because they are saying that my qualification is not good enough to run a genetic laboratory.
Medical persons having postgraduate qualification, MD from either such and such, was a mandatory component as per the existing rule to supervise this advertised checkup. Advanced. Hence, these medical persons are indispensable for running the diagnostic. Yes.
So my qualification is medical geneticist.
What does medical genesis mean? It requires MD. Are you an MD?
No, no, he is MSc in zoology.
MSc in zoology is not the. I do not know. Page 96 mentions postgraduate qualification from either pathology, biochemistry, microbiology, medical genesis was the mandatory component. Postgraduate qualification. Medical geneticist. If you want to come prepared, I can give you time.
Yes, madam. Yes, madam. Give me some time.
A and B is also, my lord, different, my lord. A says, my lord, the infrastructure was having shortage of space, and my lord, B, my lord, is not in this. I do not know what is B is. Then C comes, and ultimately, my lord, now therefore, considering the whole gamut of the case, the undersigned is of the view that unless and until Manoj Niyogi equips his diagnostic clinic with the above criteria as observed by Dr. Tapan Mukherjee, HOD, Department of Biochemistry, Medical so and so, there is no cogent reason of awarding license and relief to the diagnostic clinic of Manoj Niyogi.
Hard submission made on behalf of the party. The learned advocate for the petitioner seeks further time to get prepared. How soon?
My lord,
Next week?
next week. Anything.
Next Friday.
Lordship.
Service is taken on record. Achha, let notice be served upon the non-appearing respondents, intimating the next date of hearing. But then you will be representing everybody, isn't it? Union of India, Dorka Nichel. Adjourn motion. Under the heading adjourn motion. (127) dismissed. Record your appearance.
My lord, I beg to appear on behalf of the petitioner. My lord, your petitioners are the biological mother and father of the respondent number 6 and the in-laws of the respondent number 7, my lord. The petitioners are pensioner, my lord, at present aged about 72 and 75 and
1 minute. Biological mother of the respondent number
6 and in-laws of the respondent number 7, my lord.
All right.
My lord.
I'm for appearing for respondent number 6.
My lord.
Your parents have come.
Yes, my lord. Hopefully he might be knowing, madam.
My lord, he is present in the court.
What do you mean to say?
I do not know personally.
No. It's not a matter of personal presence. Your mother and father has filed writ petition against you.
Yes, madam. Yes, madam.
And did you file the wakalatnama?
Yes, my lord, already in department.
All right.
I'm for
Are you
number 7.
7 is here.
My lord.
7 and 6 are
Husband and wife.
Husband and wife.
husband and wife represented by different councils.
My lord.
All right, yes.
My lord, this is the case where the petitioner, who is the absolute owner of the property in question, my lord.
Who is owner? Petitioner?
Petitioners are the property in question, the self-acquired property of the petitioner number 1, my lord. The petitioner is a retired person, my lord, aged about 75 and 62, my lord. They have been ousted from their own property by the at the hand of the private respondent, my lord. And both, my lord. They have taken shelter in Kolkata, my lord, since the last July 2023, my lord. And they are residing in a tenanted premises, my lord. No maintenance is being given by the private respondents.
Go before the maintenance tribunal. There is
My lord, I have approached the maintenance tribunal, but they have refused, my lord. I have stated in the para number 27, my lord.
Application annex that they have.
Wait, please wait.
Kindly come to the para number 27, my lord.
Fighting your father.
No, not at all.
And
The
your
case
mother.
Case is
My lord.
otherwise, my lord.
Case is otherwise. Let me see.
I have stated para
How
number
many children do you have?
only 2, my lord.
Only 2.
My lord.
Who is the other one?
Other one is also an advocate practicing this court, my lord. Tanmay Mukherjee, my lord.
All right.
Majumdar, I'm sorry. Tanmay Majumdar,
Yes.
my lord. If 75 years old person cannot be run from pillar to post for ends of the justice, where the property is his self-acquired property, my lord.
The learned advocate, who is the son of the petitioner,
My lord.
he has not been made a party. And is the son looking after the father?
My lord. He
That
is
son
taking,
is-
my lord, in Kolkata, my lord, he is taking care of the mother and father, both, my lord.
And is there a difference between the 2 brothers?
My lord, he reside in Kolkata and the petition number 6 reside in the Uttar Dinajpur, my lord.
Yes, there is a fight between the 2 brothers.
No, my lord.
No fight.
No,
All right.
my
then.
lord. The only period, my lord, I want to enter into my property, my lord, and I have given notice to the private respondent number 6 to vacate my property, my lord, and so that I can enjoy my property till the rest of my life, my lord. The notice is annexed at page number 39, my lord. Till date, my lord, my position, my own property.
Where is the order of the tribunal?
Tribunal have not entertained the application, my lord.
Where is your application?
That has been stated page number 27, my lord.
Stated, show me some document. Why
refused,
the
they
tribunal?
have refused to accept the application, my lord.
Maybe it was not informed. That is the reason it has been refused.
I have made a representation before the DM, my lord. Concern,
Not the representation.
my lord.
You have to make a formal application.
Kindly
Where
come to
is
the
that?
page number 27, para number 27, my lord.
Paragraph number 27 will not do. Yes, son.
I am suffering from lumbar spine disease since for last 26 years.
What is your age now?
My age 42 years. I am an
42.
advocate working at Raigad and
You
living
both
in
the sons are advocate.
Yes, my lord. Both the
All
sons,
right.
and then there is no good relation. What has been submitted, good
Yeah, that
relation,
I can understand.
not developed. And this is a medical certificate.
No, I understand. Now what has happened? You have driven out your father.
That is not at all the case. I am living in only 10 by 10 foot room.
How many rooms are there?
Rooms. My lord, I am showing the plan, the extent of what I am possessing.
Plan also you have.
Yes, my lord.
Everything is
Considerable amount
in
of money
their
has been
custody, my lord.
invested while construction of the house even.
They have immensely tortured me, my lord, and FIR have been lodged against the private respondent, my lord.
No sour relation as such was there. I have not even lodged a case even against my parents because maybe some misunderstanding, it will end in a good relationship. I want that always.
So let the father go over there and reside in the house.
No objection at all. No objection.
But the petitioner do not want to keep them in their property, my lord. And the private respondent cannot be allowed to be in position out of the will of the parents, my lord, with the absolute honor of the property, my lord.
No such application is forthcoming. No annexure is made. Whether at all such application has been made.
The property is the father's property.
Yes,
There is no doubt.
No doubt. No doubt.
Now, maybe for some reason, I do not want to specify the reason. I can understand the reason. The father does not want the son and the daughter-in-law to stay over there.
I will little child of 2.5 years at present.
You are an advocate?
Yes, ma'am.
Find out a place for yourself and let the father live in peace.
Grateful, my lord.
My lord, then in that case, my lord, I have also such certain contentions, my lord, let it be relegated because I have been fortified with 2 orders of the coordinate bench where the matter has been relegated to civil court. For adjudication for vacating of the premises, it cannot be done by the writ court.
My lord, kindly come to the section 27, my lord.
I am not looking into that.
My lord, 27 bar the civil code, my lord.
Property is the father's property.
Yes, my lord.
He
But
has
I have
the
invested
right.
certain amount while construction of the property. That
He
is all.
has the right. When was the property constructed? When was the structure? Plan is of the year? Plan is of the year?
The property has been developed
When?
by the petitioners itself, my lord.
When?
So that to take instruction of
My lord, I humbly
You want a share in the property because you invested for construction.
Yes, my lord.
What about the father's investment upon you for your
not
education
denying-
and the studies
I am
and
not denying the
everything?
fact. Let us all live together, my lord. Let us
Live
all live
together.
together.
The father is not willing to stay.
In that case, my lord.
Yes, then in that case, find out an alternative accommodation for yourself.
Please.
And don't insist the court to pass an order of eviction.
My lord,
My
I
lord,
am the
kindly-
respondent number 7,
kindly-
the wife of the respondent number 6. My lord, I am a Muslim lady. I am also an advocate by profession. My lord, the dispute actually stemmed from when I got married with the respondent number 6. Though they were present in the marriage, but after that they couldn't accept me. I moved heaven and earth. I did whatever I could to please them, my lord. And they are saying that they were assaulted, my lord. Kindly have a look, see who is being
This
assaulted.
is not the issue.
I have
Don't show.
they
It.
kicked me I had a cesarean operation. At the point of stitch, they kicked me repeatedly, my lord.
My lord,
I
they
have
are-
I have
Better.
medical documents.
It
I did
is
not
better
lodge a
not to stay with these people who kicks you in such manner. It is better you move out for your personal safety,
My lord, I have a
for your health.
I have a small child. Where
So
will I
what?
go at this point of time?
Both are advocates. You cannot find an alternative accommodation
We are
for
senior
yourself.
advocates, my lord. We are just enrolled into the bar. We have been practicing. We do not have that kind of
You have been enrolled in
my lord,
2016.
sustenance
You
to-
have to find out something for yourself.
My lord, we will try. Of course, we can try. But provided
Please do
right
try.
now, one person cannot just forcibly throw us out.
No,
After
since
marriage
this
was
is
solemnized.
property, since the property is his, you cannot forcibly stay inside that property.
My lord, I wasn't brought into that home forcibly. Our legal marriage was done.
Your marriage with the son, fight it out with the son.
Yes.
The
You have to claim
father-in-law's
against the
house,
your husband.
cannot
I
have.
don't have any claim against anyone, my lord. I haven't filed even a single case.
You
Even
have
this,
no-
I have the medical documents.
No, you
but
can
still I-
always file.
You-
Nobody is standing in the way of your filing
No,
proceedings
I'm not.
against anybody.
My
That
lord, I
is
wouldn't
your
do that,
right.
my lord.
That is your right.
For
You
the
can
family
proceed.
prestige, I wouldn't do that.
If this is the family prestige that you are concerned of, then please maintain the dignity of yourself, of your husband, of your child, of the profession. Especially since you are of the same profession.
Yes, my lord. And I have been doing that, my lord.
Please do it.
Steadfastly.
And find out a place where you can move out.
My lord, that would take certainly some time. I just cannot.
I can give you a month's time.
My lord, more than that. 1 month, I have in this cold season, my lord, I have a young child, and that too
He
after that
70
cesarean operation, my lord. There were
75
multiple
years old, has
complications.
been suffering from cancer. He have recovered from the cancer, my lord.
My lord, my husband has spent.
No
about
matter
10
how much you make submission, since the owner of the house is not willing to keep you there,
My lord.
it cannot be helped.
Then, my lord, let the owner of the house go to the civil court for eviction if that is what she
Section
wants.
27
Let
bars
him
the
accept
civil
his
court, my lord. Kindly come to the section 27. No civil court shall have jurisdiction.
If you insist upon this type of provision, then I'll be compelled
No, my
to
lord,
pass a mandate.
No, my lord, I'm not insisting. I'm
Please
merely,
do not. Find out a place. I'll give you a month's time.
my lord, I'm
Please
merely
find out.
beseeching your lordship, my lord. I'm
Nothing
not
to beseech.
insisting.
Please come.
Grateful. এক মাস মধ্যে খালি করার
My lord, on the basis of the complaint, police has started a specific case and charge sheet also submitted.
My lord, I rely upon some judgment, my lord. Yes. It will help me to. No jurisdiction.
The petitioners are senior citizens. The son of the petitioner, not the son, one of the sons of the petitioner has been impleaded as respondent number 6 in the instant writ petition, and the wife of the respondent number 6, that is the daughter-in-law of the petitioners, has been impleaded as respondent number 7. Stop. The petitioner number 1
It had to reach everybody service.
Claims to be suffering from cancer. Stop. Allegation is that the petitioners were forcibly driven out of their own house. Stop. The petitioners were tortured in the hands of the private respondents. Stop. The petitioners approached the where have you mentioned that you approached the tribunal?
Para number 27, my lord.
27.
Page 15. Page 15.
But then you have to show documents. I will see it. I'll give you time.
আপনি গিয়েছিলেন তো
27. The petitioners approached the concerned subdivisional officer, Raiganj,
petition আছে কি
under the provisions of the maintenance and welfare of parents and senior citizens act, 2007. Show me the document.
My lord, that document is at the home at Uttar Dinajpur, my lord. He have approached কোথায় document কোথায় ওটা বাড়িতে আছে বাড়িতে at Uttar Dinajpur cannot be produced, man.
The petitioners are unable to produce any documents in support of the said submission, allegedly because all the documents are inside the house at Uttar Dinajpur. And the petitioners right now do not have any access to the said house. Stop. Prayer has been made to permit the petitioners to reside in their own house peacefully. Stop. Complaint was lodged before the Raiganj police station, but no action is reported to have been taken. Paragraph. The learned advocate representing the respondent number 6 denies the allegation of cruelty. Stop. It has been submitted that the private respondent is a practicing advocate in the district of Uttar Dinajpur.
Order pass, please.
Stop. He had spent considerable amount in raising construction of the subject house where the petitioners are currently residing. Stop.
But it is a false statement, my lord. The construction has been developed by the petitioner itself.
Where did the petitioner work? Number one.
Petitioner is retired from the transport department of West Bengal.
North Bengal State.
See?
North Bengal State.
No, North Bengal transport.
NBSTC.
Hmm.
Achha. And your age is 42. Achha, the respondent number 7 is also a practicing advocate in the district of Uttar Dinajpur. Stop. It has been submitted that the private respondents do not have any alternative accommodation, and they are not in a position to vacate the house at present. Stop. It has been submitted that the petitioners may approach the civil court for relief. Stop. Paragraph. On a query from the court, learned advocate representing the respondent number 6 submits that his client is currently aged about 42 years. 42 years. Stop. The petitioner number 1 is a retired employee of the North Bengal State Transport Corporation, and he is getting pension at present. He is now, after being driven out from his own house, he is currently residing with his other son, who is a practicing advocate of this court.
No, my lord. There is some correction, my lord. He is residing in separate rented premises.
Achha, he is staying in a separate rented premises. And the other son is also
residing somewhere else.
He is also not looking after the son.
He is giving some fooding and clothing, my lord, but nothing more than that.
Acha, ठीक है. The petitioners fervently pray for a direction by which they can reside at their own house safely and peacefully without any interference by the private parties. Stop. Learned advocate representing the state respondents has obtained instruction from the inspector in charge, Raiganj Police Station, signed on 12th September 2024, which mentions that the complaint lodged by the petitioners on 1st August 2024 was considered, and in response thereto, Raiganj PS case number 773/24 dated 1st August 2024 under sections has been registered.
Under section.
The investigation is proceeding. Stop. Paragraph. To allow the learned as the petitioners are fairly senior citizens and they are feeling unsafe to remain in their own house, in the presence of the private respondents, and especially because of the allegation of cruelty leveled against them, the private respondents ought to find out an alternative accommodation for themselves. Step. The petitioners are legally entitled to enjoy their own property according to their own wish and desire. Step. The matter stands adjourned till 17th of February 2025. Stop. Learned advocate representing the state respondents shall come up with an updated report on the adjourned date. Stop. In the meantime, the private respondents shall take steps to find out an alternative accommodation, to shift out from the house of the petitioners, so that the petitioners can reside in their house safely and peacefully.
My lord, affidavit of service be kept with-
Service is taken on record.
and I am relying upon some judgment of the different courts, my lord. 17 তারিখ আবার থাকবে আগামী মাস।
My lord, I seek your lordship's kind pardon, my lord. Just the earlier matter 127, the other side is here, my lord. I was running from court number 28. My matter got dismissed for default, my lord. Other side is here. If your lordships kindly, my lord, allow.
Once it has to be restored and then only hearing. Your other side remaining is not going to help.
I know, my lord.
Please
Kindly,
wait.
very urgent matter, my lord.
Please wait.
My lord, grateful.
এই 127 এর
129
ফাইলটা পাঠাবেন না।
হ্যাঁ
Who is your other side? 127? Please wait. I'll take up these matters and around 1:15 I'll come back to you. So by this time you all can leave by 1:15.
I will come back.
Please.
Grateful, my lord.
129 129
129?
I am for the petition.
I am for the licensee WBACDCL.
The petitioner is a goldsmith, doing a business for goldsmith in a rented accommodation. All on a sudden, the landlord disconnected the line. On request, they have not given any accommodation. He has applied for his own. He has applied for his own
Yes.
new connection. So the authority could give him the quotation, paid the quotation, everything was complete. They came at sometime to give the connection. The landlord again behaving opposed. Then he have went away. Therefore, I am going to the police. Police has said that we go before the court and proper order.
Who is the respondent number 4? Did you serve?
Four.
Show me the service. Take the service. Let me see the service.
Four is a landlord. A service is done to everyone.
Yes.
We have went there for giving connection, but the private
Could not.
respondent
Objected.
yes. Therefore, we returned.
ফেরত আসতে বাধ্য হয়েছে প্যারাটেন
So even if the bailiff permission is not there, since he is in occupation, you are supposed to provide electricity
Yes, your lordship.
under
We are-
police protection.
Yes,
Please come.
under police protection.
under police protection.
The electricity connection cannot be given to the petitioners.
My lord, I am for the state.
Yes. Because of the objection raised by the respondent number 4 being the landlord of the petitioners. Stuff. Paragraph. As electricity is an essential commodity, the same ought not to be objected. Stop. The WBACDCL is directed to cause spot inspection upon notice to all the necessary parties to ascertain the feasibility of providing electric connection to the petitioners. Stuff. The spot inspection shall be conducted in the presence of the police officers from the Shampur police station. Stop. Next. In the event the licensee finds it feasible to allow electricity connection in favor of the petitioners, then steps shall be taken to provide connection upon compliance of all necessary formalities at the earliest, but positively within a period of 4 weeks from the date of compliance of the formalities. Stop. Next. The private respondent is restrained from interfering with the act of WB SEDCL in SEDCL at the time of causing spot inspection and at the time of granting electricity connection, if found feasible. Stop. The electricity connection will not create any right, or equity in favor of the petitioners. Stop. The civil rights of the parties will be decided by the competent civil forum. The petition disposed. Service taken on record. ওই হয়নি ভুল হয়েছিল চেক করছে আমাদের চেম্বারে কখনোই ওরা হ্যাঁ সেটা ভুল করেছেন তো ওখানে চেকও তো হয়েছে নম্বর ওরা চেক করেই না
I am for the petitioner in this matter. Well, a notice inviting tender was floated.
For
State.
Who is the authority? Notice NIT issuing authority?
Joint Director, the Project Director and Deputy Director, Health Services.
You are there for the
Yes.
yes.
Now, my lord, a tender was floated for supply of, my lord, single blood bags and also 3 UA stopcock medical items, my lord. That was a story of, my lord, 2014 notice inviting tender before your lordship is there in the first annexure at page 25. But I straightway take your lordship to clause 21 at page 38.
Why are you coming now?
My lord, the bills, those who are, my lord, being raised by us, my lord, has been substantially, my lord, deducted an amount, my lord, in the form of penalty, where I was not at all responsible for paying any penalty because the original contract was over and beyond the original contract, if supply is made, I should not.
Contractual obligation, you go before the civil court for settling your dispute. What will the writ court do?
There is no dispute to be settled. It is on the face of it, it appeared that the default clause will operate up to the date of termination of the contract. Termination of the contract in terms of the said agreement, my lord, is already over. Termination is over, my lord, because I committed delay in supplying. I am the executing person, my lord, for the contract. The Poly Medicare is the original contractor whose favor the order was given. My lord, the Poly Medicare or myself, both are, my lord, in default. Within 60 days, we could not supply. Let us, my lord, say it very frankly to your lordship. As a consequence, my lord, the tender stands terminated. After that, my lord, I continued to supply because of the demand by the authority, which is not covered by the said contract. Penalty up to the period of contract, I am not disputing, if anything there. But he cannot, my lord, subsequent
since it is not a
Where
supplement.
is the order for subsequent supply?
The entire list is in the appeal also, we have said, that page 62, if your lordship kindly comes.
Appeal over where?
We have preferred an appeal. This departmental appeal provision is there in the
Alright.
contract. Page 73, my lord, is the appeal that through the special secretary. Entire table is given here.
Yes.
There was a deduction on account of penalty 48,92,208. And without applying mind, the same was disposed of by the appellate authority. At page 75.
Yes.
Not dealt with the points raised. Very cryptic order. In support of the claim, North Enterprise has cited that due to non-supply of the blood bags in time from the principal approved vendor, they could not supply within in due time, which cannot be considered as a logical ground for consideration of their application. My main bone of contention, if it is beyond the scope of the contract, whether the question of penalty will come, because it is covered by the penalty clause.
But then these things I do not think.
I will not be inviting your lordship to that. Let a report be filed by them, my lord. On the basis of the report, lordship dispose it of.
On the basis of the report, fresh cause of action will arise.
We shall file a challenge the said. The report if comes, my lord, with giving reasons, we shall challenge in a separate forum. Kindly undertake, give or take out undertaking for
You
that.
go before the forum right now. You are already delayed.
No, I have already gone to the appellate authority. Appellate authority in 2019, my lord, has dealt with the same. That is at page 75.
And did you have any privity of contract with the authority?
I have no direct contract. I am the supplier. Bills are paid to me.
Please come.
Bills are paid to me directly. That is the contract. That is the charm of this particular contract.
Aggrieved by the order passed by the.
Identically, two phases of supply were there. One blood bag and the three-way stopcock. Three-way stopcock, identical facts. Where I am also a supplier. There is no deduction of penalty.
Negative equity cannot be considered by the
negative
court.
equity is arbitrary conduct on your part.
Who is this DS? Drug and equipment, health and family DS.
Possibility indicated.
Page 75.
Yes. Order itself.
Deputy Secretary,
Deputy
Deputy Superintendent. Deputy Secretary.
It has to be Deputy Secretary.
Deputy Secretary, Drug and Equipment, Department of Health and Family Welfare, Government of West Bengal, dated 2nd March 2020.
That is the forum, my lord.
Rejecting
I have no other forum.
prayer
No
of the
alternative forum.
petitioner.
And no reason has been given.
Rejecting the prayer of the petitioner for
waiver of the penalty.
Releasing the money claim as demanded by the petitioner.
We paid for waiver of the penalty clause.
Achha. Paragraph. The petitioner prayed for waiver of the penalty clause, by which a sum of rupees 48,92,208 stood deducted from the bill of the petitioner on account of delay in supply of goods. Stop. Paragraph. It appears that there was no privity of contract between the petitioner and the state respondent.
I was authorized to step into the shoes of the original contractor by the contractor himself. And that has been accepted by the authority.
Petitioner claims to have been authorized by the original contractor.
And that has been accepted by the authority.
Supply the goods.
At page 51, if you lordship page
and the said goods were duly accepted by the state authority. Stop.
Payment is directly made to me, not to the agent.
It has
not
been
to the original
submitted that
contractor.
payments were directly made to the petitioner.
So therefore, we have a
paragraph. The tender in question pursuant to which the goods were supplied is of the year 2014. Stop. The because of the delay in supply of goods, comma, the contract of the contractor stood terminated.
Yes,
Certain penalty was imposed.
in this subsequent contract. Subsequent supply, after termination, new supply.
Imposed. Stop. It has been submitted that the penalty amount was deducted from the subsequent supply made by the petitioner. Stop. Where is the document authorizing you for subsequent supply?
Page 51 is the authority, and that clause itself, my lord, speak of that you cannot continue as a contractor any further. That's why I have taken to your lordship page 38. 21 clause is the penalty, and ultimately, my lord, termination clause at page 39. 60 days, my lord, beyond that supply made, termination.
Wait.
There shall be a system generated blockage of failure to supply.
To deputy.
Enter supply, I will be blocked and blacklisted.
Where is your communication with the deputy director? Did the deputy director ever authorize you?
Deputy director, my lord, I have been,
Polymedicure authorized you.
Polymedicure page 51 is a letter given by the Polymedicure to the prince or to the health department.
Yes. Now from the health to you, is there anything?
Health is accepting me, my lord. Health is accepting me as the original contractor. I stepped into the suit.
May I just clarify on this point, Millet?
Yes, please.
Millet, the condition is that, Millet, once the person becomes successful in the tender, he can, Millet, supply the same or continue the same as a, Millet, appointing any other sub-agent or
all right.
Now he is being stepped into the shoes of the same. So naturally is bound by the contract.
I accept that I am bound by the contract.
The payment which has been allegedly deducted, not allegedly, the payment which has been deducted is an account of the contractual obligation in between the parties. Stop paragraph.
This similar treatment of two contracts have been made.
The court is of the opinion that the writ court will not be the competent forum to decide upon the contractual obligation in between the parties. Stop. It will be open for the petitioner to approach the competent forum for.
I have gone the competent forum as per the contract, but the appellate authority was there. That order of the appellate authority is subject matter of challenge. Appellate authority's order is the subject matter of challenge before your lordship.
There is
redressal of his grievances, if so advised.
Yes.
Stop. Acha. The writ court.
At least appellate authority give a reason order.
Explanation of the delay, my lord.
Inclined to entertain the prayer of the petitioner, more so because of the reason that there are several disputed questions of facts which are to be adjudicated to grant relief in favor of the petitioner.
But dispute not been raised by any authority before your lordship.
Writ petition fails and is hereby dismissed.
What the dispute is raised? No letter has been given about the dispute. Only
Next.
delay point.
Call the next matter.
Lordship, I appear for the petitioner bank.
Yes.
I'm for the statement. Lordship, my due is around 7 crore. I have filed section 14 application before the district magistrate. In spite of this honorable court's direction upon the district magistrate, it is filed in September 2022. And till date, it is pending. There's a direction, it is at page 96, Lordship. For the expeditious hearing. The operative part is page 97.
Even after this page 96, no steps have been taken?
Yes, no.
Yes. Hearing is going on. Both the parties are taking part in
Lord,
the hearing.
Lordship,
How can
last
they come up with a
hearing
second writ petition
conducted in
in
June
executive disorder?
24.
Had
In
the-
June 24, last hearing was conducted.
My Your Lordship kindly sees the next date is hearing of date, it is 30th January, and it is the final date, and the order
Lordship,
will be
the
passed.
order was communicated in
They are coming.
March 24 itself.
Action under section 14. Hearing is going on.
The direction was for expeditious hearing, preferably
They
within
would have
3
preferred
weeks.
contempt. They would have, it had not been done in time. They are
Lordship,
coming with a
as per the
second-
Act, within 30 days, it should be completed.
You would have filed a contempt.
Listen, the court directed in March to conclude it within 3 weeks. That
hearing-
period is long over.
That has
Lordship.
been done because in the meantime, dispute arose with regard to the nature of the land. The land found out to be vested. Subsequently, DL and NRO was directed to inquire into the matter. The matter was inquired into and finally
Lordship,
it was
4 intimation were gone to them.
Your Lordship, this is the 4th date of hearing. My Lordship, kindly sees.
Yes, I can see serial number 4, date of the order is there.
Lordship.
In November, the hearing is taken and the date is fixed on the January.
No, my
When
Lord.
yes, I can see
yes,
it.
Yes, Lordship.
When 3 weeks is the time, the date is
understand,
given
my
in
lord.
January.
But the hearing is, in the meantime, many difficulties arose and because the respondents have come up with an one-time settlement proposal.
I have been rejected to make
They
a
have come up with a
before the
proposal.
authority.
Your
I
Lordship
pray
kindly
this-
sees.
That has been rejected by
They will pay
That
the
was
amount
not-
of 2.5 crores.
And filed the essay application before the appropriate forum, bank tribunal, and I had filed a OA application before that is already time to time matter is hearing.
OA
Sorry,
before OA before LRTT.
Lordship, bank tribunal, OA.
OA before the bank tribunal.
Bank
Essay.
tribunal, bank-
Essay before the bank tribunal.
There is no stay, Lordship.
Already bank had filed an essay.
There is no stay.
And 2 matters is already hearing before the bank tribunal. I had challenged the decision of the bank.
Lordship, I'm just praying for an appropriate order to the
This will be
section,
possible
as per
next day.
section 14, Lordship.
Your Lordship kindly sees the order. Your 1 minute. Your
It was
Lordship.
in March 24, the order was passed, Lordship.
Please come. The application filed by the bank under section 14 of the Surfacey Act is pending consideration till date. Stop. The bank approached this court on an earlier occasion by filing writ petition being WPA 7237 of 2023, which stood disposed of by the court on 12th March 2024 by directing the District Magistrate Purva Bardhaman to dispose of the petitioner's application as expeditiously as possible, but positively within 3 weeks from the date of communication. Stop. The time period to act in terms of the order passed by the court expired long back. The DM is yet to dispose of the said application. Stop paragraph. It has been brought to the notice of the court that the next date fixed by the district magistrate is 30th of January 2025. Stop paragraph. The mandate of law is that the application under section 14 is to be disposed of within a period of 30 days and latest within a period of 60 days from the date of filing the same. Stop paragraph. The court has already fixed an outer limit for disposing of the said application. Stop. The DM ought to have disposed of the same within the specified date. Stop paragraph. The writ petition is disposed of by directing the DM to take immediate steps for disposal of the
Lordship, may I be permitted to pray one thing? Please not, kindly not dispose of the writ petition until they are complied with the order.
Last
Lordship.
order is already compulsorily made.
May I be
Your Lordship kindly sees the last line. Lordship kindly sees the last line of my report. Your Lordship kindly sees. It has been fixed and it has been said that whatever the
Let
result
the
comes,
date-
out, order will be passed. Your lordship kindly.
My
keep
lord,
the
let the date be fixed for the compliance, my lord.
Last line means what?
You
The
la-
bank is
the
directed to submit a report whether the borrower has
The bank
turned up.
is thereby directed to submit a report whether the borrower has turned up or not. In the event of failure on the part of the borrower to settle the dispute amicably, order will be passed accordingly on the next date of hearing. My lord, the next date of hearing, the order will be passed, my lord.
But the DM is not acting as per the mandate of the statute.
That I understand, my lord. Then your lordship kindly fixes a date, fixes a time.
কি বললাম?
The information is disposed of by direct from the district magistrate who can take steps for disposal of the
Disposal of the application of the bank in accordance with law.
Much obliged.
This is a matter, my lord, where, my lord, my client has, my lord, served 2021 election, my lord, regarding supply of diesel generator set and other electric equipment. my lord. Subsequently, I made application for my lord,
Payment.
my lord. That is due, my lord. Partial payment is there, my lord, but all total payment that is pending, my lord. And my lord, other matter, my lord, the similar type of matter, my lord, honorable court, my lord, pass an order, my lord. You also can see that.
What is your submission? Are you there for the state?
For the state, my lord, he has made a representation that is on page 31, my lord, it can be considered, my lord. The lordship direct for a report, I can.
How can it be considered, my lord?
Regarding his payment.
This is a matter of, my lord, my payment, my bank loan is there, my lord. I am suffering my lot, my lord, for the last 4 years, my lord. Several.
Similar matters are pending before this court.
Yes,
You possibly are not aware with the instructions. You are
been-
not aware.
I have been briefed only in this matter, ma'am. I have been briefed only in this matter, ma'am.
Are you aware of the instruction in this matter?
There are no instructions.
Yes.
Adjourn for a week, I will come back on Monday.
Very easy, isn't it?
Right.
It's very easy. Huge amount is pending in favor of the petitioner. The writ petition was filed in September. In the mid of January, you say the matter to be adjourned only for permitting you to take instruction. Isn't it?
Right.
What would have happened had you appeared for the petitioner?
Only.
Had you prayed for the same submission, would you have made the same submission as you were making for the state? You would not have. You have pressed.
Within 2 days, my lord.
Subject to correction, this is a matter, money, my lord, not state government. This is a central government money for the purpose of expenses incurred election purpose, my lord. This is not a state government property, my lord.
এই মামলাগুলোর ফেব্রুয়ারিতে এটা রিটার্নেবল
এটা পরেরটা।
ঠিক আছে? I'll pass order. There is already a committee that has been constituted by the Secretary Home Affairs, right?
Yes.
The court has passed order for filing a report within which the payment is to be made. And possibly, if I can correctly remember, 29th of February, it is made returnable. I will, 29th of February, no, 29th of January. Check up the order. Boishali jane the order আছে. Check up the order.
I'll fix it up first week of February, my lord.
No. It will, so all the matters will take place on the same date. Next also same? 133 also same?
Yes, my lord.
Who is for this
For the
state?
state, madam.
Are you aware of that order which has been passed?
Yes, my lord, one matter, my lord, your lordship has passed, adjourn those matters, my lord.
Yes.
Date has been fixed.
Not one.
Several
matters. 29th of January, take
29th.
instructions. A very strict order has been passed. All right, 133 also, same order.
29th of January. সব মামলাগুলো একসঙ্গে হবে।
Deeply applied, my lord.
But I'm for the state respondent.
Your Lordship, I am for the petitioner in this matter. This is my affidavit of service. Affidavit of service to the Dada, affidavit of service.
What is it?
Your Lordship, I am a online trading technology platform wherein I give invoice discounting under the trade name of TradeCred. I have a master escrow account, and there are small accounts under me who do trade and give discounts. Your Lordship, page 24 is the letter by which I am aggrieved. There was one account which had done nodal escrow account, which started allocating funds in its own account. And so the police, an FIR was lodged by a concerned person. And so the police issued a notice under 91 to the bank by which I have the escrow account. And the bank has under 91, Your Lordship, my first plea is that the account cannot be freezed because there is no magistrate order. 91, page 18 is the section of 91. 91 doesn't empower the police to freeze any account, bank account. And Your Lordship, at page 19, I have myself lodged a complaint against the fraudulers stating that we operate a digital website by the name of TradeCred over the last 4 to 5 months. An organized syndicate working in collusion comprising of these fraudulers have used their respective child virtual accounts allotted to them to collect money from unsuspecting individuals and diverted them to their own personal account, violating terms of the escrow nodal account. As a result, cybercrime across have against resulting in main escrow account being frozen. Your Lordship, because of the notice issued under section 91, page 17, my entire account has been closed and the amount over here involved is only 50,000. Your Lordship, in similar matters,
yes,
page 50, before the Kerala High Court, this matter was the same petitioner, Your Lordship. Page 50, the petitioner's name is the same. Page 51 is the order which was passed on 28th November. Even though the petitioner has filed a memo showing service of notice, there's no appearance on behalf. The learned government pleader on behalf of the respondent says the dispute amount is 15 lakhs. As far as the particular incident is concerned, in the 4 circumstances, I direct second respondent to confine the freeze of the petitioner's account only to the 4 amount and no more. I, however, clarify there is any other independent. There was other orders also passed by Bangalore, Karnataka High Court, Your Lordship, which is at page 53. The petitioner is the same. Page 54 is the relevant order. The learned counsel for the petitioner submits that the notice issued under section 91 and 102 of CRPC directing respondent to bank to mark lien on the sum of 15 lakhs plus amount in the bank account belonging to the petitioner is in contravention to subsection 3 of section 102 of CRPC. The learned High Court government pleader accept notice on behalf of respondent 1 issued notice. The petitioner is permitted to operate the bank account except for the lien amount of 15 lakhs amount. Your Lordship, page 55 is the order passed by another order, Your Lordship, wherein learned counsel for the petitioner contends by virtue of impugned notice email dated 5th of March 2024 issued by respondent, Deputy Superintendent of Police Cybercrime Cell, Mohali, the master escrow pooling account of the petitioner company has been freezed, notwithstanding the allegations was with respect to misappropriation of a tune of 83,000 only. Notice of motion for itna issued. In the meantime, the order freezing the master escrow pooling account of the petitioner company is modified and the aforesaid amount is ordered to be operated by way of creation of a lien to the extent of the alleged misappropriated amount of...
Who is appearing for respondent number 4? Yes. What is the amount? How much? Where is the
14
figure?
lakhs, 14 lakhs.
Where is the figure?
My lord, I have the report with me with indicated.
Page 17, your lordship, fourth line, the figure is there. Transferred his money, 14,32,000.
How many accounts are you operating?
Your lordship, I have 5,000 customers.
5,000?
5,000 and the entire
all over the India.
Country, whole
Pan
over
India
the
basis.
country, you are doing
Everywhere
this
the
thing?
same thing is going on.
Your lordship, because we are giving discounts. We have a master account wherein the other companies join in and they give that this discount will be given through this for whatever purchases they do, like Mitra or other things. And we are just giving a platform for them to operate and give the discounts, your lordship.
You are a platform for all this corruption to take place.
Your lordship, but we have been operating since 6 years. This is the only fraudulers which we have mentioned in the FIR. We have ourselves lodged an FIR. Apart from that, there had been no complaints at page.
The complaints will come one by one. People are getting aware. Because of lack of awareness, these complaints were not filed. It's not that the corruption is not going on or the fraudulent transaction is not going. The transactions are going on. Maybe reporting is less.
And kindly gone through my report.
Let me see.
Cyber crime. My lord, it is a part of the case diary. My lord, please kindly see the flags. And
the case, where is this case going on?
Chandan Nagar, your lordship, cyber crime.
My lord, Chandan Nagar cyber crime has giving that report. And my lord, second thing is, my lord, it's the part of the case diary, my lord, which I have given a flag mark from where your lordships can find the last flag mark that we have also paid for unfreeze. But the amount which was reported should be, my lord.
Yes.
My lord, kindly see the conclusion portion that 14 lakhs should be in lien and remaining part should be unfreezed.
How much amount do you have in your bank right now?
My lord, kindly see, my lord, my report.
Yes.
My lord, that report. My lord, hand it over.
Around 10 crore of rupees.
My lord, kindly see my report. My lord, kindly see first page, second paragraph. During the investigation in this case, came to learn the victim has lost 14 lakhs and 32,000 by fraudulent. Several bank accounts are involved into the crime. From the collected bank statement, we learned that as per the direction of the fraudulent, the complainant transferred 5 lakhs and out of 14 lakhs to the ICICI bank by account number such and such. And thereafter 3 lakhs 71,000 and then 3 lakhs 94,000. We have transferred fraudulent to the DBS bank on that. Then, my lord, during the preliminary investigation, next page, my lord, it reveals that the said transaction is fraudulent transaction. So, requisition was sent to the nodal officer to DBS bank to provide the transaction details. My lord, we have already done it. My lord, that is placed before your lordship. And we request.
Account is in negative balance INR 35 lakh and odd. There are multiple liens marked on the said account. Unable to initiate the requested refund.
We have also paid for an unfreeze, but that two, my lord, 3 lakhs 71,000 and 3 lakh 94,000 should be kept in. And after that, my lord, if anything remains, that will be unfreeze. As per the directions of the Honorable Court in the various.
This 3 lakh 71 and 3 lakh 94 marked to be fraudulent transactions. So these are more and over and above 14.
My lord, this is included inside the 14.
Inclusive. Please come.
And my lord, FIR, my lord, part of the case diary, my lord, first page is the FIR.
The bank account of the petitioner stood frozen in view of the direction passed by the Cybercrime Police Station, Chandannagar Police Commissionerate. Stop. The bank account of the petitioner was found to be involved in fraudulent transactions. Stop. A sum of rupees 14.32 14,32,000 has been found to be transferred fraudulently in the said account. Stop. Paragraph. A criminal proceeding
Your Lordship, the nodal escrow account is of one Banwari, which was found, Your Lordship. That is linked with the main master account. So we are nowhere even named in the FIR because we are not involved in it. Your Lordship, I have pleaded in para 6 as well, the same. That nodal escrow account of one Mr. Banwari was
proceeding being FIR number 75/2023 dated 10th November 2023, Chandannagar Cybercrime Police Station is pending consideration before the learned trial court. Stop. Next. The petitioner relies upon orders passed in its favor by the High Court of Kerala, wherein the direction has been passed to confine the freeze only up to the disputed amount. Stop. Paragraph. The bank does not have any objection if the amount over and above the amount found in the fraudulent transaction is directed to be defreezed. Stop. Next. In view of the above, the bank is directed to restrict the freeze of the bank account of the petitioner to the tune of rupees 15 lakh. Stop. The petitioner shall be permitted to operate the balance amount in the subject bank account. Stop. Next. The petitioner shall be duty bound to comply with all the conditions and to comply with the formalities in connection with the criminal trial that is proceeding. Stop. The writ petition stands disposed of. The report filed by the Inspector in Charge, Cybercrime Police Station, Chandannagar Police Commissionerate, dated 5th of January 2025, and the supporting documents forwarded by the police be retained with the records. Service is taken on record.
Sincerely obliged. ওই মামলাটা আপনি
May I be
127.
Now I am for the petitioner, my lord. Now this is my petitioner's office. My lord, the petitioner is the owner of a 12-wheeler truck, my lord. And my lord, he is using this vehicle for carrying of sand upon issuance of all the requisition documents from the concerned authorities, my lord. My lord, on 16th of January 2024, my lord, a specific case was started against the driver and the petitioner, my lord, who is the owner of the vehicle, my lord, alleging that I was carrying 550 CFT overload sand, my lord, and to that, my lord, I was granted bail, both the driver and the petitioner. My lord, my lord, the truck was seized by the concerned, my lord, Khondogos police station. While the truck was in the seizure of the police station and custody of them, my lord, the BLRO Khondogos, my lord, without intimating anything, they have locked my vehicle and denied to issue any challans. Though the vehicle was released by the ACJM, my lord, upon furnishing of 6 lakhs bond, my lord. And my lord, till date, my lord, that lock has not been opened, and for which, my lord, I cannot pay the monthly installments also, and the my lord, this truck
Then
is...
why did you not approach the learned court below where the direction was passed for releasing the vehicle?
But my lord, the thing is that BLRO Khondogos, my lord, has not requisitioned in the learned court below. Without requisitioning, my lord, he has passed this order
Where is the order? Is there any written order?
No written order, but
By force.
by force, the vehicle has been locked. No challans will be issued for carrying any further sand.
He is doing all right. In case your presence is required, I'll permit you. Yes. So you want release of the vehicle?
I want my vehicle should be unlocked so that I can carry sand upon issuance of valid challenge from the.
And where is the vehicle now?
Vehicle is with my custody, my lord. It has been released by the SCJM upon furnishing of
vehicle is with you, but it has been locked by
locked
the
by the PLR for carrying of sand, my lord.
Yes.
Yes. My lord, kindly seize Rule 51 of the West Bengal Minor Mineral Concession Rules 2016.
Yes. What does it say?
Kindly seize.
It permits you to lock the vehicle.
My lord, that is the
When?
petition, page 70, my lord, I am handing over. My lord, subject to correction, it's an independent proceeding. For carrying illegal sand, FIR has been registered and steps has been taken. The block development officer, he is exercising power of a quasi-judicial authority as per the statute. Lordship may kindly seize 51.
50 any person
50?
extracting any mineral without a proper diesel license or storing transport shall be punishable with imprisonment. Yes,
My
that
lord,
is
the
all right.
person carrying sand,
Yes.
it is not the question of having registration and papers of the vehicle. It is a question of having papers relating to carrying of sand. Now, my lord, kindly seize page 127. There is also a specific rule for transportation of the sand. 127 of this, my lord, manual.
Yes, 127.
7. My lord, kindly seize the relevant rule. My lord.
Prohibition on transportation.
Yes, my lord. Provision on transportation.
Yes.
The person has to have a bona fide document while carrying this sand. The petitioner do not possess anything. Even in this red petition, he has not annexed a single scrap of paper that there is a valid license for carrying sand. So, my lord, there is a provision of e-locking that has been done by the concerned block development officer. My lord, in the event the penalty will be imposed, it has to be assessed, it will be imposed. The moment the petitioner pays the penalty, well, e-lock will be opened and the vehicle will be handed over to him. The criminal case will take its own
course. Show me the license for you to extract and transport sand.
My lord, page 13, my lord, kindly considers permit in respect of goods permit, my lord.
No, goods permit does not mean sand permit.
My lord.
Did you pay royalty?
My lord.
Show me the documents.
My lord, it starts from page 13, my lord.
13, yes.
Transport department.
Goods permit. What is the good that is mentioned? This is the transport department goods permit.
Goods permit. I can carry any sort of goods, my lord.
No. Sorry, sir.
Well, then let me take
Sorry.
instructions on that, my lord. If he has some documents with regard to carrying of sand, my lord, I will come back if your lordship kindly allows, my lord.
Then you can go before the BLLRO and show
Yes,
the documents
and my lord,
get it
subject to
released.
correction, lordship may kindly seize one provision. My lord, why I am saying, my lord, kindly seize the rules which I have handed over 2016. There is a provision of appeal and review. So, my lord, alternative remedy is there. In the event the petitioner is aggrieved by any action of the BLLRO, he can, my lord, avail the provision. Lordship kindly sees that 2016 Rule 51, there is a provision of appeal.
Yes.
Yes. So, my lord, the petitioner can take steps. Kindly, lordship may kindly.
No. Possibly 51 he cannot approach because an order has to be
My
there.
lord.
Here
No
there
order
is
is
no
there,
order. It's only the action that is.
My lord.
But the action against
Yes, Mr.
that.
Mondal. Now I'll permit you.
Lord.
Any document to show that nothing.
Lord, what I am on.
Yes.
Lord, we have made Lord prayer before the concerned BLR.
Where is it?
My lord. Well, that is at Annexure P5, page 24.
That can be considered. Nothing
lord.
more than
My
this.
Kindly give that.
Please come. The petitioner prays for consideration of the legal representation filed.
Only this this may be kept on record. This is the instructions by the BLLRO.
Achha. On his behalf, seeking unlocking of the vehicle which was used for transportation of sand. Stop paragraph. Learned counsel representing the state respondent submits that there are no documents in favor of the petitioner permitting him to transport sand. Stop. The report by the additional district magistrate and the district land and land reforms officer Purva Bardhaman produced in court today mentions that the vehicle of the petitioner was e-locked, e-locked by the BL and LRO Khondo Ghosh. Stop paragraph. The same was done in accordance with Rule 50 within bracket 1 of the West Bengal Minor Minerals Concession Rules, 2016. Stop. The as it appears that the petitioner prays for a consideration of the legal representation. Accordingly, the instant writ petition is disposed of by directing the
Respond number 4. Respond number 4.
Blockland and Land Reforms Officer Khondo Ghosh, respondent number 4 herein, to consider the prayer of the petitioner in accordance with law and permit the petitioner to place documents in support of his stand. Stop. A decision shall be taken in the matter at the earliest, but positively within a period of 4 weeks from the date of communication of this order. Writ petition stands disposed. Take back your book.
These instructions, my lord, may be
Is retained with the
My lord,
records.
extreme urgency, my lord. Just I
My lord, only in
my
this
lord.
matter, my lord, only one line, since no affidavit has been called for, because it is
As the writ petition is being disposed of without calling for any affidavits, the allegations made therein are deemed not to have been admitted by the respondents.
My lord, extreme urgency, my lord. I was asked to come back, my lord, by your lordship, my lord. This is a matter which was filed tomorrow, and filing number has been
Filed
generated.
tomorrow?
Yes, sorry, my lord.
Yesterday.
Actually, yesterday, and filing number has been generated, but I am just about to wait to get the number, register number. And difficulty is that, my lord, tomorrow the bank is supposed to take the possession as per the notice, whereby the order has been passed by the additional chief judicial magistrate Birbhum. Arambagh Birbhum. My lord, according to section 14 of the Surfacey Act, district magistrate or the metropolitan magistrate, but here the violating the provision and exceeding the jurisdiction, this order has been passed. And the bank is supposed to take the possession tomorrow. My lord, kindly give it to be mentioned tomorrow in the
To be mentioned.
so that, madam.
Hearing and consideration in the to be mentioned.
My lord, as per my lord, just consider.
To be mentioned, I do not take up hearings.
Wherever lordship will be
No,
pleased
but then ADM doesn't have the same power as the DM.
no, madam, my lord, this according to this provision, my lord, Surfacey Act, metropolitan magistrate either or the district magistrate has the power to take to direct the for taking the possession, my lord. Learned ACJM has vested its power.
ACJM or ADM? ACJM.
ACJM.
All right.
And tomorrow is the date, my lord, to take the possession, my lord. This is the
Very well. Tomorrow, as urgent motion, you serve notice upon all the parties.
Yes, my lord.
And you come prepared as to whether the ACJM and the CJM has similar powers or not.
Right, my lord. And another thing, my lord, non-prosecution matter, if you lord.
No, now is not the time for mentioning non-prosecution. This is the urgent matter. I have permitted you. Give the number tomorrow as urgent motion, subject to your serving notice upon all the parties.
Right. Much obliged.
Ma'am, just to mention, there is some confusion of the timing of the contempt because I have to take permission to send the matters to the respondents.
Yes.
Because I've got one case at Justice Titanga Ghosh at 3:30 in the original side. So in case I'm just in timing, I'm not there. I just wanted to know that.
Which is your item?
There are number 364 and number 369.
364 ख्याल रखना तो 369
Number
is it
364 and number 379.
79?
Yes.
And is it appearing for the first time?
Yes, first time.
Let it be called on. I'll pass orders for service.
Okay. Ma'am, grateful, ma'am. Grateful.
Yes, call the list.
Met position. Run off for the petition. My lord, if I can take your lordship, my lord's order, passed in the writ petition once. Your lordship will find at
Where
page
is the other side?
I believe my lord, Lanet Fin, my lord is appearing for the others.
Yes.
Mr. Barman. So my lord, page number 20 is my lord's order.
You seek transfer to a school where service will be required on regular basis. DI has failed. Matter may be placed for the commissioner for reconsideration.
Because that is only after my lord, lordship's order of page number 20, my lord, 31st January 2024. It is the...
Any update, Mr. Burman?
I do have...
Yes. Lordship, Commissioner has also passed an order confirming that since there is only one teacher, so at this moment transfer cannot be made. No arrangement also could not be made, alternative arrangement.
Before seeing that, if your lordship kindly sees my lord's order.
See, if this is what the commissioner says, that means you are to stay in that school. You will earn your salary, but there will be no teacher and no work for you to do. This is the ultimate thing.
This is, my lord, what the commissioner is wanting. By
And if the state wants you, where is your problem? You go there, earn money, and
My
finish.
problem is this, my lord, because of this, for this empty formality, my lord, I'll have to go, my lord, 700 kilometers from my residence. This is the problem. This is why I came before your lordship. My lord, once, because this is also a contempt, why I tell your lordship, page number 20 of my lord's order once says, because everybody is not applying their mind. I do not know why.
This is required to be challenged in a fresh writ
It does,
petition.
my lord.
I have gone to the extent of setting aside the order of the TI. Now this has a detailed one, so you have to go into it.
I'll
Please come.
do that, but before that, if your lordship kindly sees once and thereafter passes the order. Once.
Yes, what?
Page number 20 of in the contempt application, my lord, of my lord's original order in the writ.
Yes. Yes.
My lord, I'll not trouble your lordship, my lord. It is first page, the last paragraph in the first page, at page number 20, 31st January 2024. In the contempt application.
Yes.
My lord, 31st January 2024.
Yes.
My lord, the first page, the last paragraph, petitioner relies upon such and such judgment,
Hmm.
where the court was of the opinion that once a teacher fulfills the eligibility criteria, authority must take step to fill up the resultant vacancy as per the norms existing in the relevant point of time by way of local amendment of such and such. My lord, now my lord kindly sees the commissioner's order.
Hmm.
Because the DI says that the commissioner says, I cannot do it unless I get a replacement. So on the other hand, my lord's order was to get a replacement after the individual goes, because this order was passed only by keeping in mind that there are three sections. If someone does not go out, nobody can come. That is a simple logic, man. If your lordship kindly sees commission.
No, but then you please come.
If this could be
The
one
order
at least
passed by
at least one reflected in your lordship's order, because on the earlier
Commissioner of School Education on 13th of January 2025 has been placed before this court. Stop. It appears that the commissioner has passed a detailed order rejecting the prayer of the petitioner.
My lord.
Stop. Next.
They're so mechanical all the time.
The school in question where the petitioner is currently teaching has a bare minimum student of how many?
Zero now 0. 4 to 5, nobody comes. Now it is 0. 11, my lord,
With
is the
practically
original.
zero attendance.
Yes, now it is 0.
Stop. The petitioner intends to be transferred to a school where he can perform his duties. Stop. The Commissioner of School Education admits that there are 3 teachers in the school. Stop. Only for the purpose of maintaining the formality in GO number 670-EDN within bracket S dated 4th September 1990.
It is not in force anymore.
The prayer of the petitioner seeking transfer has been rejected. Stop paragraph. I am afraid that sitting in the contempt jurisdiction,
My lord.
it may not be proper for the court to enter into the legality and validity of the order passed by the commissioner. Stop. Next, in view of the above, the contempt application stands disposed of, granting liberty to the petitioner to challenge the order passed by the Commissioner of School Education before the competent forum in accordance with law, if so advised.
Grateful. Grateful.
Your Lordship, Mr. Mitruka is appearing on behalf of the petitioner through video. I am assisting him.
Please, my lady. My lady, I appear for the petitioner. My lady, if this is the contempt application coming up for the first time, if my lady sees page 40, that is the relevant order passed by my lady on 27 September 2024.
Who is the concerned respondent to answer?
This is the Commissioner of Siliguri Municipal Corporation.
All right.
My lady will see page 40.
But then the writ petition is pending?
No, my lady, this was the first order. The second order, which was finally passed, is at page 42. And my lady will come to page 44, where the direction is at para 15.
A decision shall be taken by the commissioner.
Yes, what my lady in a nutshell directed is that a decision be taken under section 268 of West Bengal Municipal Corporation Act. My lady will now see the commissioner's order, which starts at page 97. The relevant portion is at page 99.
If you are aggrieved by this order, then you ought to have filed a fresh writ petition. Why come up in contempt?
Yes, my lord. May I just explain, my lord? And my lord, for that, could your lady please see 268 for a moment? What the commissioner has done, my lady, is that put a condition before even considering my undertaking given for repair. What your lady had directed the commissioner is that if I give an undertaking for repair, the commissioner will consider it in accordance with law. But instead of considering the undertaking, the commissioner has, my lady, put a condition to say that you first give me a stability report. And my lords, there is no basis for this stability report. In fact, my lords, the commissioner has put the cart before the horse. Today, my lords, we are in a situation where the assumption is that the building may not be in a stable condition and therefore the repair. But what the commissioner is saying that you get the stability report first, I will see that and then I will consider your undertaking for repair, my lords. So, my lords, that's the reason we have approached your ladyship in contempt. And, my lords, another thing, my lords, this is the third or fourth round of litigation. Every time there is a direction passed by your lordship's court, the commissioner does something else. We have to file fresh writ after fresh writ, my lord. This is the fourth proceedings.
That does not mean that you can come up in contempt to challenge the correctness of an order that has been passed.
No, my lords, I bow down, my lords, but all my submission today is my lady will see your lady's order and see what the commissioner has done. There's complete divergence. My lady will see page 99 for just 1 minute.
Yes, 99. I am at page 99.
Yes, my lady, if I may read out with your permission, what the commissioner has finally ordered that in regard to consider the building to be fit for human habitation, the provision wide subsection 6 of section 268 of so-and-so must be complied with. Also, the structural inspection report of impaneled structural engineer needs to be based on a test result so-and-so. And, my lords, ultimately what the commissioner says, penultimate paragraph, the petitioner is hereby directed to submit the structural inspection report by the empanelment structural engineer accordingly on or before, failing which necessary order will be passed. My lords, she doesn't talk about the undertaking. She doesn't discusses your lordship's order. She goes on to a completely different tangent, which is alien to 268 also. If I may, your lady refer to 268 for a minute. 268 doesn't even talk about any structural report.
This is a very good ground to set aside this order in a writ proceeding. I'll give you leave. Please go.
Milords may at least call her and Milords get Milords ask her as to why such an order is passed. We have written at least 5 letters.
Aggrieved by the correctness of the order. Now, aggrieved by the order passed by the Commissioner Siliguri Municipal Corporation on 11th November 2024, allegedly in compliance of the direction passed by this court in WPA 2077 of 2024. Passed by this court on 1st October 2024. The petitioner stressed that the said order is contrary to the direction passed by the court and not in conformity with section 268 of the West Bengal Municipal Corporation Act, 2006. Stop paragraph. I am of the opinion that the correctness of the order passed by the commissioner cannot be adjudicated in the contempt proceeding. Stop. The validity of the said order has to be tested in a fresh writ proceeding. Stop. Next. In view of the above, the instant contempt application is disposed of, granting leave to the petitioner to approach the competent forum in accordance with law for redressal of his grievances, if so advised.
My lady will kindly consider, my lady, the order is completely contrary to what the High Court had directed.
Your prayer is contrary to the direction passed by the Honorable Supreme Court. This is the reason I cannot go into the merits of the impugned order.
Very well, my lady. I'm grateful.
But I am for petitioner. My lord will kindly come to page number 12 of the contempt application, my lord. That
is it
the order.
appearing for the first time?
My lord.
Serve.
My lord, the problem in this matter is that your lordship had set aside a notice of the respondent number 3 in the writ petition by the impugned notice had blocked the challan of my truck to carry sands from one destination to another. your lordship had set aside the notice and had directed the ADM DLRO Puro Bardhaman to immediately release the vehicle from the said block. But till date, my lord, the ADM DLRO Bardhaman has not taken any step. We have communicated it. We have also, the order was not of communication, but still we have communicated it to the ADM DLRO. But still he has not, we have annexed that also, my lord. Do that we have communicated it. And the track report has also been annexed, my lord. The track report says, page number 16, it says that on 26/12/2024, it has been delivered. But my lord, still here, the alleged contender has not taken any steps to remove the block. And my lord, till date, my truck is standing as it is.
But this lock was given. Show me you had the right to carry the sand.
Yes, my lord. My lord, may kindly comes to the main writ petition, my lord.
Yes.
My lord, may kindly takes up the main writ petition. My lord, page number 14 of the main writ petition. That is the e-challan, my lord.
E-challan?
E-challan, my lord, we will see kindly that I had the permit by the ADM DLRO Birbhum to carry the sand. And my truck was intercepted by ADM DLRO Puro Bardhaman, which I do not agree, because my lord, the notice was issued in the name of another person. My lord, may kindly comes to the next page, page number 15. The notice was issued in the name of Rohimul Haq Mullah.
All right, you serve.
My lord, may kindly gives this matter some preference, because my without any rhyme or reason, my lord, my truck is standing. Notice is issued in another person's name, and I do not know whether this person is either related to me or not.
Notice serve first day. Returnable on 30th of January.
My lord, may kindly
Fortnight.
My lord, may kindly gives me a week's time. I will serve the notice, my lord, kindly, my lord, because my
yes, but they are required to come. The next Thursday is a holiday, so the following Thursday is 30th. I have kept it.
My lord, may kindly keeps it at the top, my lord, because my lord, it has been
my lord. Item number 1. It will be there in item number 1.
My lord, if doesn't direct, then it will go according to the CIS posting, and it will go at the last.
No, put it at the top.
My lord, oblige, my lord.
30th.
I'm for the petition, affidavit of service, grant leave to add the present Pradhan as a party. The container is the previous Pradhan. No,
No, not first time. When did the contemner change?
1 year, present election.
Election took place long back. The order was passed only in November. You did not seek time to seek direction for changing the incumbent. Please come. Leave granted to the. None represents the contemner. Stop. Leave granted to the advocate on record of the petitioner to implead the present contemner as a party in the contempt application and serve copy of the contempt application upon the current incumbent. List on 20th Bishop February. An affidavit of compliance shall be filed by the present contemner on the adjourned date. Yes, 135.
My lord, it is that matter regarding that felling down of tree, that Bondumur tree. My lord, there was a direction upon the divisional forest officer to cut down the tree and take appropriate decision in that regard, and along with the fact of granting compensation to the petitioner. My lord, till date the tree continues to stay there. Right now, in order to take vengeance, they have planted more trees. It is encroaching into our property. We have time and again we have sent contempt notice to the concerned authority. It is during the when the matter is running into this, now we have been informed that some other person is now in charge of the divisional forest officer. My lord, as for which liberty is required to be taken to make the necessary correction, to incorporate the name of the present divisional forest officer.
But the thing is, if I can correctly remember, in this matter, nobody was willing to cut the tree.
Private respondent. It was private respondent.
Private respondent resisted, but then nobody was willing to cut the tree.
No. It was private respondent only.
It's a private respondent.
Yes, Your Lordship. Lordship, kindly come to the order dated 9th October 2023.
The DFO has not passed any order.
No, my lord. In the meanwhile, they have moved to the divisional bench. Divisional bench prevailed the decision of this honorable court.
Where is the order of the division bench?
My lord.
Office of the Puruliyas, you are
I'm the petitioner.
Nila Datta. Pradeep Giri, I see there is a communication from the chairman of the municipality for deposit of cost for felling the tree. Otherwise, legal steps will be taken.
They haven't taken anything.
They have not taken any steps.
No, my lord.
So who is going to bear the cost?
My lord, it is the private respondent who is supposed to take the cost. I am facing damages just because of them.
What is the order of the division bench? Let me see once.
Order of the division bench.
Give me the case number so that I can see from here. Please come.
Let me come.
The petitioner alleges violation of the direction
MAT 997 of 2023, Your Lordship.
passed by this court on 9th October 2023. Stop. It has been submitted by the learned advocate for the petitioner that a new incumbent has joined as the divisional forest officer. Stop. Prayer has been made to implead the present incumbent as party respondent. Stop. Paragraph.
No.
You have impleaded the chairman of the municipality as contemptor.
Yes, Your Lordship.
What the direction was?
And the direction was upon the divisional forest officer.
Then you did not implead the DFO as party.
I have, made him the party, but the thing remains now
Where is the
officer
party?
has changed.
Where? Show me that the DFO has been made as party.
My lord, page 5, my lord.
Yes, page 5. I can see only the chairman of the municipality.
Versus, my lord, this Sri Anjan Guho, present divisional forest officer, Kongshabhurti.
Page 5, I can see Nobendra Mahali. This is Niloy Dotto's matter?
Yes, Your Lordship.
এটাই তো contempt. এই তো সিপেন। draft copy বোধ হয়। হ্যাঁ, নিলয় দত্ত। হ্যাঁ, সন্দীপ গিরি আছে। ওটা তো পার্টি ছিল পিটিশনে, রিট পিটিশনে। তারপর আচ্ছা, এটা প্রথমে ড্রাফটে ছিল, তারপর ড্রাফট থেকে আর চেঞ্জ করেনি, ওইটা ফাইনাল কপি, আর সেটা এখানে আসেনি। কি বললাম? ভায়োলেশন অফ দি অর্ডার ডেটেড সাচ এন্ড সাচ, ঠিক আছে। হ্যাঁ, prayer has been made to implead the the present divisional forest officer as party respondent in the contempt application. Start paragraph. It appears that the divisional forest officer has not been impleaded as party contemptor in the instant contempt application. Stop. It is only the chairman of the Purulia municipality who has been impleaded as contemptor. Stop paragraph. Learned advocate for the petitioner seeks leave to amend the cause title of the contempt application and implead the present contemptor as a party in the contempt proceedings. Stop. Leave sought for is allowed. Stop. Let the erstwhile divisional forest officer and the present divisional forest officer be impleaded as contemptors in the contempt application. Stop. Let copy of the contempt application be served upon the contemptors, intimating that the matter will appear in the list on 27th of February 2025. Affidavit of compliance shall be filed on the adjourned date. Did you not check in the list? It is written the chairman of the municipality as party, and in your brief there is the chairman is not a party.
My lord, there has been information from my
Yes.
grateful, your lordship.
On this matter, after receiving the copy, but they want to take steps. Therefore, I am praying only not today. If they want to take steps
What
for
steps you will take?
demolition.
Out of 331, my lord, 311 has been demolished, 20 left. We have taken step for demolition of the rest 20.
So therefore, my lord, not today, my lord.
22nd is the date
Let
of
them.
the demolition. We have issued notice about my landed court, and we, in the meantime, I will send it.
Did you get your fees, remuneration, or only smile?
Only smile.
All day.
Only smile.
Only smile. Please pay him.
No, I have paid. I have paid.
I did not fix up the amount. It
No,
is you.
yes, brother. But they have said, brother, I have given 10,000 rupees, 500 left. No, brother, he had said, brother, he had said, brother, that is enough. Therefore, brother, I shall today.
He says partial payment, and moreover, had the court fixed up the amount,
No,
then
no.
the court could
No,
have
I told him. I
It
told
is you fixed up the amount.
Yes, brother, I shall.
If you have promised something, please.
But I promise before the court, tomorrow I shall give 5,000.
Yes,
Yes.
whenever.
Promise. But next on 30th.
Please come. Learned advocate. Learned advocate. The petitioner appears in person and submits that the matter may be adjourned for the time being, as the contemptor is taking step to comply the court's order. Stop. In view of such submission, list the contempt application on 6th of February 2025. আচ্ছা একটা লাইন লিখে নিন তো the balance payment of the remuneration of the special officer shall be made prior to the adjourned date.
I am appearing on behalf of the petitioner, my lord.
Order complied?
No, my lord. If your lordship kindly see the last few orders passed by your lordship.
You order.
And, last occasion, my lord, we have given a comprehensive report saying that on 9/12/2024 onwards, the building is to be demolished. Date was there, demolition was done, but not completed. No, my lord, no demolition. Kindly see the present photographs, my lord. Then let them call G+1 sanction, G+5 story constructed, my lord. This is the last photographs, my lord. Kindly see. This is a big building, my lord. Not this is the last. I am placing the compliance report previous. I have given the date was 9/12/2024 onwards. It is not a magic that it will be within 4 or 5 days the demolition will be completed. My lord, order was passed in the year of 2022. If he is satisfied that a rule may be issued, I think
Kindly see the photographs.
I don't know what will happen because your lordship directions is being complied with timely and timely. Well, let some
Only
date,
G
some
plus
time may be
one
given.
sanctioned.
Maybe.
How much demolition has taken place?
But last floor and thereafter, but debris was there. We are clearing that. We are continuing the demolition.
My lord, nothing has been demolished.
Very well.
Sometime maybe.
Bring photograph.
Yes.
This is the current photograph.
And I am sure, my lord, if your lordship give me 2 months time, I can complete. I don't know whether again it will be completed. We have 4 floors extra, my lord.
See, the photograph suggests
They
that
have
no
taken the
demolition has taken
Much
place.
before.
No,
No, my lord. Kindly
date
see
is
the date.
there. The newspaper date is
Yes.
there.
Listen, give me the photographs. I will call them.
Please give a photograph.
Yes, my lord.
Give a photograph to your learned friend. Please come.
And demolition squads officer.
ছবিটা শুধু দিয়ে দিন ওনাকে।
My lord, the next date, the building department may be present virtually. I am assisting your court, lordship's court. Because I want to do it.
The demolition of the unauthorized construction.
Or I will make him present if your lordship do not write also.
Not been conducted. Stop. Learned advocate for the contemptor submits that partial demolition has taken place.
তোমাকে সামনে দেখাচ্ছি পেছনের দিকে তো এগুলো ভাঙা হয়েছে
দাঁড়িয়ে আছে ওনার ইনস্ট্রাকশন
photograph of the unauthorized construction
আপনি আপনার
has been placed before this
নেবেন আর আমি আমার
stop at the same retained with the records. Stop. On the prayer of the learned advocate representing the contemptor, the matter stands adjourned till 13th of March 2025. Stop. An affidavit of compliance along with the photographs of the subject structure shall be produced before this court on the adjourned date. Stop. In the event the unauthorized construction is not completely demolished by the said date, who is the concerned person?
Concerned person is the Malad Gopal Chakraborty. He is the main demolition head.
No, contemptor. Who is the contemptor?
Let me be added, man.
Contemptor, my lord, the commissioner.
Shruti
Ranjan Mohanty.
Shruti Mohanty is not there.
Vitika Mandal দিয়ে দিয়েছে।
Has been changed.
Where is the brief? Brief কোথায়? Acha, then the
Gopal Chakraborty. Let the name may be added at least.
who is he?
He is the demolition head.
No, demolition head is not responsible.
He is the building engineer also.
He is the building engineer.
One of the building engineers.
Acha, the concerned
And the demolition
engineer.
head.
The concerned engineer responsible for conducting the demolition work shall remain virtually present.
My lord.
Stop. Leave granted to the advocate on record of the petitioner to implead the current incumbent as party contemptor in the contempt application.
One thing, my lord, if
Grateful, your
he
lordship.
is physically present, then not.
Let us see.
I can bring him physically also.
Once virtually, next physically.
No. I will bring him physically. Then it will not harmful. He will come.
Grateful, your lordship.
If he can come, very well.
Yes, madam.
Very well.
Bring him
Next.
physically. And only this part of the order is very vital for me.
Lordship, in this matter, Lordship, I am appearing on behalf of the contemptor number 3, Lordship. This affidavit and compliance should be filed, and affidavit
for the petitioner, my lord.
Affidavit of service also be here. To Judge Sahib to kindly to the kindly, my lord.
You are for the petitioner?
My lord, I am for the petitioner.
Yes. Order has been complied or
yes,
not?
My lord.
Let the order be downloaded at least by tomorrow. The order may be downloaded by tomorrow.
Yes, it will be put up in the server.
I am starting the demolition from next week.
I will put up in the server.
Lord, I beg to appear for the petitioner, my lord.
Interesting thing, my lord.
1 minute. You are for the petitioner?
Yes, my lord.
Yes, has the order been complied?
Yes, my lord.
Complied?
Yes, my lord.
Now
let me say, my lord.
Same could not be complied with. What is your name?
My lord, my name is Mriganko Patra, my lord.
Who is the advocate on record?
Uday Narayan Betal.
Where is
Narayan Betal's junior says here.
My lord, I'm junior, my lord. Yes, my lord. He's engaged, my lord.
he is engaged? You are the?
I am the contender number 3, my lord.
Yes, 3 or 2?
3, because name is Mritika Mondol.
All right.
My lord, now.
No, he says the order has been complied. Why will I hear you?
Now may I say one thing? Very interesting thing. Order complied or not, because who is now filed the writ petition before you, and on that basis of the contempt order was passed, he himself has no any sanction plan and produced before the because 22nd.
You take any steps against any person who has done something?
Because kindly, Lordship, I'm seeking one directions. The Lordship, let this matter, but already this SDO already I referred, but SDO has not given any.
Already he has taken.
Kindly take this. Already they gave directions to the SDO, the compliance order. Already they have because in person Lordship's order. I am
Learned advocate appearing on behalf of the petitioner submits upon instruction that.
My lord, report page number 16, my lord.
Order
Annex Z.
passed by
Annexes,
the court
Lordship,
has
right
been
now may I say, Lordship?
complied with.
If Lordship kindly
Stop.
give me brief
In
time,
view
my
of
lord.
the aforesaid submission, the contempt application stands disposed of.
Now, Lordship, one thing, my lord, this resolution is book. They have this admitted.
Affidavit of service and the affidavit of compliance.
An affidavit of
filed in
compliance.
court today be
But
taken
they
on
have the
record.
resolution is a complied. They have no any sanction plan. Who is the appearing before your, my lord?
If the
That is my-
petitioner does not have a sanction plan, who is stopping you from taking steps?
Lordship, that is
Take steps.
Lordship. Kindly give the one seeking the Lordship indulgence, they give directions to the SDO, my lord, they take steps, my lord, because ultimate authority of the subdivisional officer already have forwarded the copy of the subdivisional, that is has been
Very
already
well. Call
annexed,
next
my
matter, please.
Lordship.
Lordship, I am for the petition.
Appearance. 139.
Lordship, I am for the petitioner.
Yes, please.
Your Lordship, one fresh application has been filed by the opposite parties. Some of the opposite party maybe the residents of that building. Your
Where is
Lordship.
the opposite party in a contract matter?
No, not
The occupier of the unauthorized building.
occupiers. One fresh application has been filed. One fresh application has been moved before the Honorable Coordinate Bench. Your
Which
Lordship.
application? Writ petition, what?
Separate writ petition was filed
Writ
by the
petition.
co-owners of the property, my lord.
Right.
In that writ petition, there was an interim order of stay that was carried out before the Honorable Division Bench, and the Honorable Division Bench was pleased to, my lord, dismiss the appeal in view of the fact that it was an interim order, my lord. This is the, my lord, order passed by the.
So right now, what is to be done?
Stay was there as on, my lord, on 11th of November, the matter was last heard.
Oh, I see it is recorded over here. The writ petition
Your
has been
Lordship, the
filed by the
stay
occupants of
was for 1 month, Your Lordship. But they haven't communicated any order to the Honorable Coordinate Bench.
undertaken. Is the stay order still
That
subsisting?
order was passed, my lord, on 11th of November, and it was extended till 6 weeks from the date of passing of the order, my lord. So in any event, my lord, first week of January was the last, my lord, week. So as on date, I do not have any instructions from my client, nor I have
Very well,
received
please come.
copy.
Acha. It has been brought to the notice of the court that a writ petition filed by the occupants of the unauthorized construction is pending consideration before a coordinate bench of this court. Stop paragraph. The contender shall take steps to comply with the order of demolition in the event no stay order has been passed in connection with the same. Stop. List the contempt once again on 6th of March.
I appear for the petitioner. This one previous occasion, a communication was handed over to me showing the alleged compliance. This is the
I filed a writ petition which was disposed of by your lordship with the direction upon the alleged contemner to implement an order which was passed by that authority pursuant an order passed by this honorable court. Lordship, if your lordship kindly come to page 26, that is the calculation made by the alleged contemner pursuant an order passed by this honorable court. The paragraph after the chart, it shows since the property in question was assessed as being fully occupied
Has
by
any
tenant.
fresh order been passed by the contemner?
No order has been passed, only a communication, even that is not at all a demand also. It was communicated to in my name and copy was forwarded to the private respondents who are the occupants of the building. This is not even a demand also. The property is fully occupied. I filed a writ petition for apportionment of rent, apportionment of municipal tax. In terms of the order passed by this honorable court, this assessment was done as I pointed out to your lordship. Subsequently filed a writ petition for implementation of the order passed by the municipal authority. In that, your lordship passed an order which is at page 27. And the direction is at page 29. The bottom portion at page 29, the writ petition stand disposed of by directing the Assessor Collector South.
A calculation is dated 29th of November 2022 has been placed on record.
Yes.
Right. This is the compliance of the order that has been passed by the court. Now, what is to be done over here?
Now, lordship, they have assessed that this portion of the property is fully occupied, so only the occupiers are liable to pay the tax. That was the conclusion of the municipal authority which was passed pursuant to order passed by this court.
You are aggrieved by the same?
No.
Then?
I am fully satisfied with that. Now it is for the municipal authority to recover the municipal tax from the occupiers. That has not been done.
Who are you?
I am the landowner.
And is the corporation charging anything from you?
The tax they are issuing, tax bill are raising on my client there who are the owners of the property.
All right. You want the bills to be raised in favor of the tenants.
And should be recovered.
And recovered from them. This is your...
No, lordship, I am the owner, primary responsibility, but when the municipal authority, they have came to the conclusion that the owners, occupiers are liable to pay the tax.
Yes.
See page 24.
1 minute. What is to be done here? The communication is in the
Municipal
name...
Corporation Act is before your lordship.
No, it is not here. 1 minute.
2 minutes.
Prior to that, this communication is addressed to the learned counsel. Why
Yes, counsel is he.
Yes. Why don't you communicate it to the client?
No, copy was endorsed to the, it is at the bottom, it is there. Copy to
everyone. Is given to everyone.
Clients are aware. If your client wants implementation or challenges, there is a forum. Why in contempt?
One small thing, my lord, allows me for 2 minutes. My lord, we have attached the rent so far as these tenants are concerned. Whatever his share, he is not paying his portion of tax also.
No, lordship.
So far,
1 minute, please.
I'm sorry.
Please, yes.
Now, my lord, there is a tax for the building. Now, say it is 20 rupees. 15 rupees has been charged upon the tenants, 5 rupees upon him. That 5 rupees also he is not paying. Now, since I cannot get the entire tax for the building, within my means, within the law, within which I perform my duty, I have attached the rent. Rent is attached. Thereafter, the law doesn't give me any other tool to go and
recover tax.
Because, my lord, why I was asking whether your lordship is having that book. 193 is very clear that liability to pay tax, primary principle. That is, and he, in no uncertain terms, he says, I am the owner of the building. If you are the owner of the building, the primary liability under 193 is upon you.
No,
and only 230 thereafter it comes.
Only one thing, lordship, in this particular case, possibly my learned senior friend has mixed up the issue with some other property.
No, with this also.
In this particular case, there is no outstanding municipal tax imposed upon the owners. Lordship, kindly have a look at page
Very well.
26.
The corporation will take steps
The
to recover.
corporation came to conclusion the occupiers are liable to pay the entire tax.
I have perused the order of the Assessor Collector within brackets South, dated 29th of November 2022, which has been passed allegedly in compliance of the order dated 22nd September 2022. The court is satisfied that the order passed by the court has been substantially complied with. Stop. There is no reason to proceed with the contempt application any further. Stop. In the event the petitioner intends to seek any further remedy, it will be open for him to approach the competent forum for relief if so advised. Contempt disposed.
Grateful. But the compliance
Is already on
is
record.
already on record.
My lord, 140, my lord, appearing for the petitioner, my lord. My lord, your lordship order dated 3rd April 2022 has not been complied yet. On the earlier order dated 22nd August, my lord, your lordship directed the corporation submitted that they shall take steps to demolish, my lord. My lord,
Issued, my lord, on 11th, my lord, and a date for demolition has tentatively been fixed, my lord. As and when we get the assistance of the police and the entire BP.
As and when you will get the assistance.
It requires some time, your lordship knows in many cases, my lord, the commissioner, due to dearth of, my lord, adequate police force or some, my lord, festivities, my lord, they do not, my lord, they provide assistance. So, my lord, our hands are tied to this extent, but we are doing our, my lord, task, my lord.
Please come. Let me see your written instruction.
The first page is the, my lord, eviction notice. Yeah, but we don't know.
A communication dated 11th January 2025, addressed to the occupants of the unauthorized structure, directing them to evacuate the same in aid of demolition, has been placed before this court. Stop. Next. Where is the letter seeking police assistance?
That letter, my lord, I failed to take a printout, my lord, but I have seen, my lord.
You have seen. What is the date?
I do not have it right now. I cannot, my lord, say, my lord. It's probably
In January.
No, my lord, not in January. In December, my lord, it was there.
How can it be in December? You give the notice in January.
January.
Achha. It appears that the unauthorized construction is standing and immediate steps are required to be taken for demolition of the same. Stop. Next. যেখানে বললাম না unauthorized construction was detected long back and order was passed by the commissioner in the year 2021. For demolition of the same. Yes, but the same is still standing. Yes. The corporation ought to take prompt necessary steps to get the unauthorized construction
indicate one thing,
demolished.
The contender number 1, that is the person responsible, she has also preferred an appeal, my lord. That is pending, my lord. It is MAT 1747 of 2020.
Appeal against?
Appeal against the order, my lord, of your lordships, my lord, where, my lord, the corporation was directed to implement the demolition order, my lord.
And that is pending.
That is pending.
No stay order.
No stay.
What can be done? Acha. Learned counsel representing the contender submits that immediately on getting the police assistance, the demolition work shall be conducted. Top paragraph. It is made clear that in the event the corporation seeks police assistance, then the commissioner of the Bidhannagar Police Commissionerate shall provide necessary assistance to the men and agents of the corporation at the time of implementing the order of demolition. The matter stands adjourned till 13th March 2025, when an affidavit of compliance shall be filed before this court.
Grateful.
In this matter, I am for the petitioner. The division bench order affirming my lord's order has been stayed by the Honorable Supreme Court. Let it go out of list for the time.
All right. Please come.
Can you see the order, man?
It has been submitted by the learned advocate representing the petitioners that the issue in question is pending consideration before the Honorable Supreme Court. Stop. Next. In view of the above, let the contempt application stand delisted for the time being.
I'm good.
Stop. Liberty to mention.
My lord, the order has been complied. Yes, my lord. Here is the police report. In total, it has been complied, my lord. Page 15 to 19.
Where is the petitioner?
He will not come, my lord. The building is totally gone.
Demolished.
Yes, 15 to 19 pages. Page 15 to 19. Police report.
The outer structures are still there.
But this was also sometimes back. Now
Very well.
nothing. Even the thing what your lordship is seeing, that is also not there. Police report, my lord.
All right, give. And appears on behalf of the petitioner at the time of call. Stop.
Police report.
An affidavit of compliance has been filed by the learned counsel representing the contemners. Stop. It has been submitted that the unauthorized construction has been demolished. Stop. The report filed by the officer in charge, Pulbagan Police Station, signed on 20th November 2024, be retained with the records. The contempt application stands dismissed for default.
My lord, I beg to appear on behalf of the petitioner, my lord.
Yes.
My lord was kind enough to pass the order on 23/9/2022, wherein my lord was pleased to direct the other side to carry out the construction, that is the landlord to carry out the constructions and to give us the possession by 15/8/2023. And we had to hand over possession back to them. We have handed over possession back to them on 13/11/2022. In spite of that, time period as directed by your lordship has elapsed. They have done nothing. What they have done is they have demolished the structure and they have put tenants in the said they have erected temporary stalls and have put tenants and are collecting rent without carrying out any kind of construction, without giving us the possession. Now your lordship kindly comes to page 143 once.
Page?
Page 143. The order starts at page 142. The relevant portion is at page 143. Lordship kindly sees the middle portion, the paragraph starting with all efforts. all efforts shall be taken by the respondent number 14 landlord to ensure that the construction is over and possession handed over to the petitioners by August 15, 2023. They have not done so, my lord. We have handed over the possession back to them. They have demolished it. Now, Lordship kindly sees what they have done. Lordship kindly comes to page 147. They have constructed, my lord, temporary stalls. They have put in tenants and collecting rent. Although we were the original tenants, we are not now out of possession.
You were also having these type of stalls?
No.
It was a residential house or
It
what?
was a commercial building. We were the tenants. We are the original tenants.
Yes.
Now the building was in a dilapidated or a bad condition. The corporation issued an order for demolition.
Which corporation?
Asansol Corporation, municipality. Now the writ petition was challenged. In the writ petition, the matter was thereafter disposed of by your lordship by the said order, which I have shown to your lordship at page 143.
We submit, my lord. My lord, on the last occasion, my lord, these photographs were shown before your lordship. And my lord, I have taken instructions from my client, and this was purely, my lord, on temporary basis, my lord. My the reasons for delay, my lord, because when the writ petition was moved and the order was passed in the writ petition, my lord, but the impression was given from the Asansol Municipal Corporation is that the moment his order is passed and the building is demolished, and the petitioner, the landlord, my lord, submits the papers before the corporation, my lord, the corporation would take steps, my lord, for granting of the sanction plan, my lord. Now, my lord, what happened after the building was demolished and we approached, my lord, the landlord approached, my lord, the corporation. It is for the first time that the corporation informed him that, look, this property, it is not mutated in your names. The record of right is not in your name. Go and obtain those first. But we had moved pillar to post, my lord, to obtain those things, my lord. But we have got that. But time and again, because if your lordship kindly comes to the parent order once, my lord. Kindly, my lord.
1 minute. These persons have given possession back to you.
Yes, my lord. Admittedly, my lord.
And you have given possession to somebody else, maybe temporarily. Why will you not give possession to these people? Even if it is temporary, why not these people?
Very well, I talk to my client, my lord. If that is possible, my lord, we will give them, my lord. But today, my lord, what is the difficulty that I am facing, my lord? But I have obtained, my lord, I have paid the mutation fees, my lord. It's a very substantive amount. But today, my lord, the mutation and my lord, the correction of record is complete. Your lordship's order was that the municipality would consider an application for grant of provisional sanction. My lord, time and again, from the year 2023, I am applying before the municipality. Kindly give me a provisional sanction so that I can, my lord, commence with my work of, my lord, construction. But the municipality says we don't have the provision of giving any provisional sanction plan. You have to obtain the sanction plan through online mode. Now, my lord, the moment I enter, my lord, the online mode, my lord, because my lord, this record of rights and everything, my lord, was not in a proper order, the online, my lord, application was not accepted, my lord.
Now you say it is in order?
It is in order, my lord. My lord, I have already applied for, my lord, conversion because it will be a commercial building, my lord. The conversion certificate is due to be given to me on Monday, my lord. But if the municipality can expedite the process of, my lord, granting the sanction plan.
Listen, all these things cannot be done in the contempt, right? There is an undertaking that you.
But I am bound by that undertaking, my lord.
You will be bound by that.
I am bound.
Otherwise, I am going to impose heavy costs. And not only this, further coercive steps may be taken against you for not complying with the undertaking.
I appreciate, my lord, the petitioner
Right.
is a brain tumor patient, my lord. He is running from pillar to post. But I individually myself has gone to Asansol, my lord, to help that person, my lord, to get all these things, my lord, done, my lord.
Now, if you have let out temporary possession of the stalls to third persons, why will the persons who gave possession to you will not be
But that was done, my lord.
given possession?
But that was done, my lord, unknowing to me, my lord. It should not have been done. If my learned friends are agreeable, my lord, to move in a temporary position, I can speak with my client, my lord.
Another important aspect, my lord, we have foregone our right for.
Prior to going to the another one, if temporary
time and
accommodation
again,
is
my lord,
given to you, are you agreeable to move in?
Lordship, kindly
temporarily.
keeps it next week. I shall come back with
Yes,
instruction.
he will also take instructions whether you can be accommodated, and you will also take instruction whether you are agreeable.
And my lord, only one
And what
thing,
is
my
the other issue?
Other issue, my lord, we have foregone our right for compensation. It is recorded, my lord, in my lord's order at
Yes.
page 143 at the first para. The petitioners forego their claim of compensation for the period they will remain out of their tenanted premises.
Now, since
To
that time
facilitate-
has passed, the court will revisit that. That is all right. What is your submission?
the landlord time and again have my lord, intimated the petitioners about my lord, what steps he has been taken in the meantime.
But then that does not absolve you of your undertaking.
My lord, I am doing my best, my lord. I can assure your lordship, my lord.
Please come.
And only one thing, if your lordship kindly sees the parents order, my lord, the parent order, my lord, kindly, my lord.
Why? What you want me to see?
There is one paragraph, my lord, it starts my lord, from the first page of the order. The last paragraph, the executive engineer of the Asansol Municipal Corporation had submitted a report before this court, which mentions that ordinarily the time period for making construction in accordance with the sanction plan is 60 days from the date of submission of the application for sanction, unless further information or document is called for. Provisional sanction may be given for erection of the building after obtaining the necessary license permission from the statutory authorities. But if this provisional sanction can also be given to me today, but I can move with the purpose of the erection of this building, my lord. Because I've also taken a huge loan, and I'm paying the EMIs, my lord, without having any mode of, my lord, income from any end, my lord.
No, you are getting rent from these people.
Very minimal amount, my lord. Minimal amount, my lord. Not compared to what, my lord, the EMIs that I am paying, my lord.
Now the municipal corporation is not a party over here.
In writ petition, they were party, my
In
lord.
petition, they were parties, but in the contempt,
If your lordship directs, I will serve notice upon them also.
we make them parties. Acha. Leave granted to the advocate on record of the petitioner to implead the competent authority of the Asansol Municipal Corporation as contemner in the contempt application and serve copy of the contempt upon the added respondent. Stop paragraph. Learned advocate representing the petitioner has drawn attention of the court to the undertaking filed by the private respondent in the writ petition to hand over possession of the newly constructed structure to the petitioner by 15th August 2023. Stop, the same has not been done. On the contrary, the private respondent has made temporary construction of stalls and let out the same to third parties. Stop paragraph. Learned advocate representing the private respondent in the writ petition and the contemner in the contempt petition submits that despite steps being taken to get the plan sanctioned from the corporation, the same has not materialized till date. Till a sanction is granted by the corporation, the petitioner cannot proceed. The private respondent cannot proceed with the work of construction. Stop. It has been now learned advocate for the private respondent seeks time to take instruction as to whether temporary accommodation can be provided to the petitioners who handed over vacant possession to the private respondent. Stop paragraph. To allow learned advocate appearing on behalf of the petitioner and the private respondent to take instruction with regard to the temporary accommodation at the subject place. Let the matter appear in the list on 6th February. Stop. Learned advocate for the corporation shall come ready with instruction as to why the plan, why the plan proposal submitted by the petitioner is not being accepted for sanction of the building.
Or only one indulgence, my lord. Instead of 6, lordship kindly keeps it on 13, my lord.
13th.
I'm grateful to your lordship.
My lord, on 13th, my lord, my junior is getting married.
Getting married? Very eventful day. What is to be done?
Lordship kindly defer it, definitely.
Defer. Very well, 20th.
I will kindly keep it on 13th, my lord. For me.
You leave your marriage and copy.
That too for contempt, my lord.
No, the court is more difficult.
The actual Miller marriage is on 20th, Miller 13th, Miller there is a separate ceremony, Miller.
Oh, in that case, 13th.
That I can defer, Miller.
I'm grateful to your lordship.
I'm grateful, man. My lord, I am for the petitioner, my lord. Here is the affidavit of service.
Lord, I am for the contempt, as per your lordship's observation earlier, my lord. My submission was this: as fund is not there, and your lordship observed to write to the government for
To
fund.
seek for funds.
8 days later.
Already, my
Lord,
lord, that issue has been decided by the division bench.
So no funds till now.
No, but what if, may I submit, my lord? Frankly speaking, submitting, my lord, that the earlier, my lord, I submitted one order from the appeal matters. Inquiry was directed. Inquiry took place. Now, my lord, what was found is this. Inquiry report আমাদেরকে দেয়নি তো এফআইআর করছি সব দিয়ে দেবো ওখানে দিচ্ছি তা না
May I get a copy of it?
সোমবার নিয়ে নেবেন No, kindly come to the last 5 pages. Last 5 pages. Firstly, the Director of Local Bodies, dated 13th December 2024.
Which portion?
Last 5.
Last?
From the last page, minute 5.
Last page.
I think it is there.
What is there? Yes, what is it?
13th December 2024. I'm sorry. It is into.
No, it is not there. Digi? 13 December 24, yes. Initiation of disciplinary proceeding against the employees of the municipality.
And then Miller.
Well, after their retirement, since we have.
I know.
Contractor
It
physical.
is admitted. I know. It is during the period of the erstwhile Miller chairman. FIR is also lodged against him.
Against which person? Who are the persons? Where are the names?
Names are there, Miller, in the FIR.
So maybe what can be done?
In the FIR, but these people are the
Why
employees.
we are in the suffering end?
They are the employees of the municipality.
Miller,
So after they have retired.
I think, Miller, on 17th September 2024, we asked for the fund. And it is clear that we have stated that 1 crore rupees, if given, then they will be paid. All Miller, not only this petitioner. There are as many as 10 petitioners. All will be paid.
See, it is not the responsibility of the state.
No, that's true.
Melody.
Then if you say that is true, then how can you?
Lordship, kindly see the judgment. In the same issue has went up to the appeal before Honorable Division Bench, and it is the decision of the Division Bench.
I think, my lord, hence
this issue, that financial crunch, we cannot pay, and that is decided by the division
we
bench.
are trying our best, my lord, to get the municipality.
And in one matter, your lordship has asked for personal appearance of the chairman on 30th. Let them come with instruction on 30th.
The instruction will be the same, that they do
Same.
not have any fund. There cannot be any new instruction.
And that is the division bench has held that they have to decide it.
How do we get the orders executed? Now I have to direct the assets of the municipality to be sold for the purpose of
That was also
dispersal of your amount.
no, that was not in black and white, but honorable division bench had said, yes, sold out your property and make them payment. That was not in black and white in the order. But my lord, we are at the suffering end.
Lord, at
And at the end of the day, we will die without any getting any money.
At present, my lord, the claim stands.
Have you implemented the director of local bodies or anybody as party over here?
No. Okay.
Only the present chairman, executive officer, and finance officer.
Lordship, keep it on 30th so that I can.
Let me see what I can do on the 30th also.
Because I shall bring the affidavit on the behalf of the state we filed in this appeal, where the state was added as a party, and what was the stand of the state, that will be very much clear before your lordship. Because state was headed by in that matter.
Does the chairman of the municipality receive any salary?
Obviously, all the councillors and salary.
No, that is different. Otherwise, he doesn't receive any salary.
No.
They get a honorarium.
The executive officer must be receiving a salary.
Yes, my lord.
He is salaried, and the finance officer also must be getting a salary from the municipality. Now, I'll be compelled to stop their salary.
Well, I think it will be very proper from my end. I think within next 2 months it will be cleared up.
It will not be clear. You are making this submission for more than 6 months.
They are paying. They are paying me, lord. Kindly have a look to this.
Very well.
Kindly have a look to this. This petitioner, my lord, outstanding to as on date. They are trying to pay.
This is Kalpana Hajra. Outstanding is how much? 5 lakh something.
5 lakh.
5 lakh 97. It is not a huge amount also. It is not a huge amount.
I have personally, my lord, taken this matter with the municipality.
No, I have shown enough leniency to your clients, but then now it has time.
May I beseech your lordship?
No further besieging.
Further 2 months.
2018 retirement. It is enough. Please come. The terminal dues of the petitioner who retired from service on February 28, 2018 has not been cleared till date. Stop. Repeated orders were passed by the court for payment of the due amount along with interest. The same has also not been honored by the municipality. Stop. In such a position, the court is constrained to pass order directing freezing of the salary of the contender number 2, the executive officer, and the contender number 3, the finance officer of the Murshidabad municipality. Stop. The honorarium received by the chairman of the municipality shall also be withheld till the entire dues of the petitioner along with interest is cleared. Stop. The matter stands adjourned till 13th of March 2025. কাগজ সব ফেরত যাবে। Return.
My lord, same order may be passed.
Date of retirement?
Date of retirement again, file.
Why Kalpana Hajra two matters?
No, one for herself and one for her husband.
The first one,
It is her.
প্রথমেরটা ওর জন্য, এবারেরটা the husband.
It is a family pension.
Harness, date of
Died in
লেখা আছে. So this will be widow pension?
Widow pension, yes.
এটা তাহলে widow pension হবে.
Here is the affidavit of service.
Yes, service is taken on record.
147 day. Affidavit of service কোথায়? নিয়ে চলে গেছে। Petition সাজানো নেই কেন? হবে এত affidavit of service সাজিয়ে রেখেছিস?
প্রদীপ,
Contempt
দুটো
petition. No, 147 is also same, 149 and 150.
1 minute, the date of retirement will change.
No, date of retirement will change. My lord, when 146.
146 is widow.
146 is there, date of retirement.
এটাতে লিখে দেবেন কিন্তু the learned advocate for the petitioner is directed to communicate this order to the contemners. ঠিক আছে? 45, 46 যতগুলোতে স্টপ করা হলো।
দীপক মজুমদার, তাই তো?
Not added, সবাই পাঠিয়ে আছে।
47.
147, date of retirement, who is the employee? Deepak Majumdar.
Deepak Majumdar, 30/11/2019.
30/11/2019, date of retirement.
Well, here is the affidavit of service.
11/2019, 30th November 2019. One
148. No.
I am for the petition.
Yes.
Your lordship's order is at page 40.
Not complied. Not complied.
Not yet complied.
What is to be done?
My lord, I am appearing for the corporation, my lord, contemner. Order, my lord's order was passed on 20 December 2022, and the special officer passed the order on 15/6/2023. Some delayed.
Order has been passed.
Yes.
Let me see.
That is also communicated, my lord.
No copy has yet been served upon us.
Please come. Learned advocate representing the contemner submits upon instruction that the proceeding to deal with the unauthorized construction was initiated and concluded by the special officer within bracket building, comma KMC, and final order has been passed on 15th of June 2023.
That is, my lord,
Let a copy of the same be served upon the learned advocate representing the petitioner in court today. Stop. It will be open for the petitioner to take necessary steps to challenge the order passed by the special officer building before the competent forum in accordance with law if so advised. It's an appealable order. Illegal construction has been directed to be retained.
Yes.
Very good ground for appeal.
Great.
Contempt disposed.
My lord, kindly mention one thing, my lord. The order passed long back, my lord, 2023 has served upon us today, my lord.
I have recorded that it has been served upon you today.
There is a provision for delay before the.
I know, but then I cannot in contempt jurisdiction condone the delay. I have recorded that you have got it today.
আপনারা তো করে দিলেন আর
My lord, here is the affidavit of service, my lord. Same matter.
Same matter.
Only the date of retirement is 31/8/2016.
31st of August 2016. And the petitioner is the employee.
Yes.
Imagine from 2016 till 2025 non-payment of terminal dues. Yes. 150.
150, the petitioner retired on 30th November 2017.
Do one thing, Pradeep, in all these matters, record an order. Leave granted to the advocate on record of the petitioner to implead the director of local bodies as contemptor in the contempt application and serve copy of the contempt application upon the added respondent. You serve.
Yes, well, I have to get the name first. Name.
Inquire about the name from the GP's office from any of the government leaders or anybody, because I'm going to stop his salary also. Otherwise, your problem will not be solved.
Now, Maki naam to.
August.
Last retirement হচ্ছে 30th November 2017.
Which one? 150?
150.
Oh, November 2017. Yes.
এই সাথে দিছিলাম।
দেখি কি ছিল দেখি।
আচ্ছা, বুঝতে পারছেন।
Dismiss for default. 152.
152. No, I'm very good.
Is it appearing for the first time?
No. Not, I have been given a compliance report in the form of affidavit, not.
All right.
Mr. Sondipan Banerjee, sir.
Yes.
Now you'll have to kindly surprised to see.
Yes.
If each floor it was sanctioned G+3, construction made G+7. Every floor there were heavy violation or the deviation, and the entire fourth floor are unauthorized. No steps taken till date, nothing. And upon March persuasion, the order was passed in April 2024.
What is the order?
After giving hearing.
After giving a hearing has been done, self-demolition notice has been passed.
No. You have annexed the order 17th of September 2024.
That is the self-demolition order. That is the self-demolition order.
Please come.
Nothing has been done till date.
That is the self-demolition order. Order is there. Hearing has been done.
Compliance filed in court
To take steps.
is taken on record. Stop. It appears that the corporation has detected unauthorized construction and order of self-demolition was passed on 17th September 2024, directing the person responsible for making unauthorized construction to demolish the deviated and the unauthorized deviated portions and the unauthorized construction within 15 days. and in default, the corporation shall take legal action in accordance with law. Stop. The time period for effecting the self-demolition has expired long back. Stop. It is high time that the corporation takes steps to demolish the unauthorized structure. Stop. Next, the contempt application stands disposed of.
Grateful. You know, kindly keep it pending not and give further time to demolish not.
For implementing this, fresh writ petition is to be filed. Yes.
For the petitioner.
Yes. Order complied?
No, impartially.
Partial? What is the balance to be complied?
The writ petition page 43. আর কতদিন লাগাবি বাবা 23 সাল থেকে
43.
Milord, kindly see what were the deviations, Milord. It has been stated. This is the Milord present Milord condition. Kindly see the top Milord that has been demolished after Milord. Milord, several orders passed by your lordship, but Milord, the floor, side open space, Milord, they are there. The shop room, all are there. I'm relying upon their orders only.
One unauthorized floor over the first floor. Beyond the provision, this has gone.
It's gone.
The unauthorized shop in the ground floor is still there.
Still there. And the side open space.
Obligatory open spaces covered by temporary shed.
On the left hand side.
Entire building is occupied other than the lessee's. Clarification is all right. But then what about the shop room and the side spaces?
That could not be Milord demolished Milord because Milord on the earlier occasion it was submitted before on behalf of the corporation that it was occupied Milord and the occupants they have Milord refused to evacuate the Milord shop. Now Milord letters of evictions were issued on 23rd of October. It is on record Milord.
All right then.
Thereafter Milord on 30th of October requests were made to the Joint Commissioner for Police Assistance, Milord, but they, Milord, refused because of the dearth of the staff. Kindly a direction be
already there. That is also there.
12th of September, I see the Commissioner of the Bidhannagar Police Commissionerate was directed to render all necessary assistance.
20th of November also, Milord, for further compliance. That was given to us in view of the fact that the top floor was to be demolished. With regard to the ground floor, that is the shops.
So each and every stage, the court has to come in only to direct the police. Provide assistance, provide assistance, provide assistance.
Milord, my hands are tied, Milord.
No, your hands are not tied at all.
Milord, will kindly, Milord,
the issuance of rule will solve the problem, Milord.
Milord, we visit there, Milord, with the men and agents, Milord, and the machinery. We face resistance. We are not the person to, Milord, to evict them from their shop or their, Milord, premises. That has to be done by the police itself, Milord. We have no power. We have the power to demolish. We will demolish.
Please come. It has been brought to the notice of the court that the unauthorized structure cannot be demolished because the same is occupied. Stop. Learned advocate representing the contender submits that police may be directed to remove the occupants from the unauthorized structure. What about the shed? The side space? There also occupant is there.
That was, Milord, to the best of my knowledge, that was, Milord, demolition.
No, he says only the top floor has gone.
No, only the top floor has gone.
Very well, Milord, kindly keeps it on the next, Milord, Thursday, Milord.
Next. The court video order dated 12 September 2024.
I have the letter
passed in the contempt application. Directed the Commissioner of the Bidhannagar Police Commissionerate to render adequate police protection to the men and agents of the corporation at the time of demolition of the unauthorized construction. Stop paragraph. The Commissioner of the Bidhannagar Police Commissionerate is directed to render is directed to immediately render adequate police protection to the demolition squad of the Bidhannagar Municipal Corporation, so that the unauthorized shop in the ground floor, which has been set up beyond the approved building plan, and the obligatory open spaces covered by temporary shed can be removed without any further delay. Stop. Next. The police shall be solely responsible for removing the occupants from the unauthorized construction, and the corporation shall take simultaneous steps to demolish the same. The matter stands adjourned till 6th of March 2025 for filing the affidavit of compliance.
Keeps these two letters on record, my lord,
Very well.
issued by the commissioner saying
Will
that
the
they are not
recorded
in a
documents
position to
handed over by the learned advocate representing the corporation be written with the records. Yes.
One 154, my lord, I am appearing on behalf of the alleged contemptor, my lord. The demolition order has already been passed, my lord. This is my affidavit of compliance, my lord.
Demolition order has been passed.
Yes.
July 24. Actual demolition did not take
No,
place.
no, not yet. my
When will
lord.
you take steps to demolish?
My lord, kindly grant us some time, my lord. We shall demolish the order.
An affidavit of compliance has been filed by the learned advocate representing the contemptor. Stop. The order of demolition. Now, it appears therefrom that unauthorized construction has been detected and direction has been passed to demolish the unauthorized portion. And direction has been passed on 11th July 2024 for demolition of the unauthorized construction. To self-demolish the unauthorized construction within 30 days from the date of receipt of the order, failing which the municipality shall take steps to cause demolition. Stop. Paragraph. Time to demolish the unauthorized construction expired long back. Stop. It is high time that the municipality takes steps for implementing the said order of demolition. Writ petition contempt application stands disposed of. None for the petitioner. লিখে দেবেন।
Below, may I kindly be allowed to mention one that in 151, you are engaged in code number 23.
Which one?
151. The Ramphal municipality led by record. Application may kindly be recorded before Lordship is so pleased to direct.
151 has been dismissed for default. কে নিয়েছে?
Just appearance may kindly be.
অরিন্দম বাবু, আপনি কি 151 নিয়েছেন? প্রদীপ একটু বলে দেবেন প্রদীপকে যে এনার নামটা দিয়ে দেওয়ার জন্য। For the municipality.
মানে 155 item number 155 I am complied, but some delay was there, that's why your lordship, my lord, asked me to file.
Has the order been complied?
Lordship, subject to Lordship's correction, I am saying that order has not been fully complied, because Lordship, in the order, solemn order, Lordship mentioned that whether the construction is legal or illegal. Regarding this issue, the concerned municipality did not touch this point, and in this solemn order, municipality said that this is civil dispute. The dispute is civil or criminal. This is not our question. Question is that whether the construction is legal or illegal. Regarding
Show
this,
me the order passed by this court
Lordship.
of which you allege violation. 25th of November 22.
Lordship, in the order dated 25th of November 2022, I have given as an annexure, white annexure P1, page number 43.
Illegal construction. Very well. Now, what is the compliance?
Lordship, for your Lordship's kind.
What is the compliance?
I filed my before your lordship long back.
What is the compliance?
Well, upon hearing and inspection, it is found that there is a kacha construction made before long back. Now they are evict the occupier by using the municipal code. That's why we have heard and considered all respect and dispose of the representation.
Lordship, regarding the Kacha construction, in the order passed by the Board of Councillor, in this order it is not mentioned that whether this is the Kacha construction or not. The question is that whether the construction.
Where is the order? Where is the order?
On earlier date, Lordship, a municipality has filed, but I have one Xerox copy also of this order, Lordship. May I be permitted to
No, no,
file?
no. Your order does not say whether the construction is in accordance with any plan sanctioned by you or not.
It's not.
On
the contrary, it says that they are residing there by making construction, tile shed construction.
Yeah.
But whether this is legal or illegal, authorized, unauthorized?
Well, actually, the construction made by the private respondent long back ago, there is a kacha construction, not a paka construction, my lord. Also, my lord, at the time of hearing, I, my lord, submitted before your lordship and recorded it. This is kacha construction.
Is it your case that plan is not required to be sanctioned for making that construction?
Yes, my lord, there is kacha construction, my lord.
Kacha construction.
I'll state, my lord, my lord, total. If your lordship asks me, then I shall file details of the construction before your lordship next day. No problem, my lord.
Lordship, along with
by our engineer.
Along with photograph.
Please come. Peruse the reasoned order of the Board of Councillors dated 28th of February 2024. Tell your officers to be very careful at the time of affirming the affidavit.
Yes, ma'am.
Because if this is the stand that plan is not required, then I will make it applicable for all municipalities. And then your officers will fall in trouble. The entire place will be filled up with unauthorized construction and you will not be able to demolish them. Keep this in mind.
Yes, ma'am.
I have seen what you have mentioned over here. And if they feel that they can simply make this type of submission and can go out of the clutches of the court, then they are utterly mistaken. Ki bolna?
Peruse the reasoned order of Board of Councillors dated 28 February 2024.
Stop. The authority was directed to consider as to whether the construction made by the private respondent was in accordance with law or not. Stop. There is no reflection in the order of the Board of Councillors with regard to the legality of the construction made. Stop. Mere recording is that the private respondent repaired the tile shedded structure. Stop. The same is not consideration in accordance with the direction passed by the law and in terms of the mandated provided in the statute. Stop. Paragraph Learned advocate representing the Board of Councillors seeks time to clarify the same. Stop paragraph. Let the description of the disputed construction be brought on record by way of an affidavit supported by photographs from all four sides of the structure.
I'm deeply obliged, Lordship.
Let such affidavit be prepared and circulated by 6th of February. List on 20th of February.
Deeply obliged.
6th of February. Deeply obliged, Lordship.
অর্ডারটা দেবে
আরেকটা লাইন অ্যাড আপ করুন তো। The Board of Councillors shall clearly specify as to whether the subject structure requires a sanction or not.
Yes. I'm deeply obliged, Lordship.
Lordship, I
Madam,
have
that the
is
petitioner
petitioner
the
in this
affidavit
matter.
of compliance,
Lordship,
madam.
I am led by Rajoshi Dotto in this matter. He has not come to the court. Lord, I am praying for a note today.
No, had already
This is the contempt matter. Let me see once.
already complied, my orders. The order passed in 24/11/2022. And the executive engineer to take steps.
Has any steps been taken to challenge the order passed by the special officer building?
Lordship,
You do
I'm
not
not
know.
having knowledge in
An
this
accommodation has been sought for on behalf of the learned advocate representing the petitioners. I see there are 4 advocates representing the petitioner.
Lordship, Rajoshi Dotto is
There are 3 of them assisting him. Where are they? What is your name?
Lordship Priyanka Gop.
Where is Shaunak Mukhopadhyay?
He is
Sayantan Bose, Ankita Chaudhary.
Lordship.
Nobody is there.
Lordship, Ankita Chaudhary was previously assisting in this matter, but she has left the firm, and
Should the affidavit filed by the contemptor be taken on record? List the matter on 30th of January. Call the next matter, please.
Obliged.
Yes.
My lord, I am for the contempt number 1. On 12th September, my lord, compliance of affidavit has been
Dismiss for default, record the appearance of the contemptors. আর AGM একটা জিনিস লিখে দেবেন তো, none appears for the petitioner on repeated occasions. Yes, next.
KMC.
I am for the petitioner, my lord. In the last occasion, Lordship
My lord, I
directed
am
me
for the alleged contemptor.
to intimate Mr. Joyita Sinha and Mr. Shondip Mondol is to appear for the state BL LRO, as it is the point that they cannot identify the plot of land. Subject to correction, my lord, I am constant to say that the unauthorized construction has been identified. Stop work notice has been given. They mentioned the specific premises number. We filed writ petition. When honorable court directed to demolish the same, they are saying, no, that premises number anticipated is vacant land. As it says that stop work notice, premises number they mentioned, when you filed writ petition, they said there's no construction premises number and so and so. Then we filed writ petition again for second time, identifying the party and bounded, plot number, quote number, etc. Now they're saying, my lord, measurement necessary. I fail to understand. I put this question myself, my lord. When they identify the unauthorized construction, what for the measurement?
Did you serve notice?
Yes, my lord, I have some
Let
notice.
me see.
Sorry.
despite notice served upon the learned advocates who represented the state in the writ proceeding. Comma, none appears. Stop. Let a notice be served in the office of the learned government pleader, intimating that the matter will appear in the list on 30th of January.
Lordship.
এই নোটিশটা রাখবেন।
I'm for the petitioner, Your Lordship.
I'm happy with the Kolkata Municipal Corporation.
Your Lordship, I have one indulgence. This is an interim order that has been passed by the municipal corporation, by the executive engineer. This is a copy. They have taken steps, they have allegedly taken steps against Lions North Calcutta Hospital Medical Center. However, Your Lordship, the complaint was originally against Lions Orthopedic Hospital and Research Center. I have the photograph against whom we have actually filed a complaint, but they have allegedly taken steps against Lions North Calcutta. It's also annexed in the contempt application, Your Lordship.
Contempt application number.
Lions North Calcutta Hospital
1607
is running the trustee.
No, Your Lordship, the agreement was with Lions Orthopedic Hospital.
Lions
We are the
Orthopedic Hospital.
Yes, Lions Orthopedic Hospital. We are the managing trustee. I have made an agreement initially against with Lions Orthopedic Hospital. Now they have made unauthorized constructions and we have filed a complaint against Lions Orthopedic Hospitals. But they have allegedly taken steps against Lions North Calcutta Hospital. This is not the same entity.
You want the unauthorized construction to go?
Yes.
Whoever has done it. Has the authority taken steps to demolish the unauthorized construction or deal with it?
No.
But in this matter, my lord, your lordship kindly see the prayer of the contempt application where my lord, my learned friend has prayed, my lord, your lordship kindly come to page 16 of contempt application. Her representations are pending before the authority. That was not disposed. Page 16. Your lordship kindly give 2 weeks time so that we can consider the representation and file affidavit of compliance.
The order alleging contempt is 7th July 2023.
Earlier occasion one contempt was filed.
All right.
No, this contempt, Your Lordship, is of the year 2023. Earlier contempt that he stopped. It's no earlier contempt. This is the only contempt application.
No. One application, my lord. No. It's different.
So from 23 till 25, you did not find time to act in accordance with the court's order.
Your lordship, only 1 week time, my lord.
Why?
Mr. Alok Ghosh is.
Whoever is appearing, Mr. Alok Ghosh is not the contemptor.
1 week time, my lord, so that we can consider.
What will you consider within 1 week if you could not consider within 2 years? What will you consider?
Representation of the petitioner.
And you will consider in such a manner so that immediately when a writ petition is filed, that consideration order goes. This is your mode of functioning to somehow not to comply the court's order.
So, my lord, not that, your lordship can allow 2 weeks time, at least 2 weeks time, lordship.
When was the representation filed, madam?
Representation was filed.
Page 17.
Page 50, Your Lordship, 16th September 2023.
What is this that you handed over to the court?
This is an interim order that they have passed.
Is the premises same?
Yes, premises is same.
Is there any other entity by the name of Lions North Calcutta Hospital over there?
I have no instructions on that. I even asked this to the client. The client does not know. So the client has also made representations asking the municipal corporation themselves to give inspection of the documents. They have not. My lord, kindly cease this representation.
November 11th, 2024, the interim order is passed.
There have to be made a representation, Your Lordship, asking for inspection.
How are you related with this property?
I am the managing trustee. There's a trust. I'm the managing trustee. The trust has made an agreement with this particular Lions Orthopedic Hospital Research Center that they would use it only for checking the patients for free. However, they are using it for commercial purposes and has made many unauthorized constructions. And they are using it for commercial purpose. So we have made representations, demolished the unauthorized constructions. They have not responded to the same. And now this Lions North Calcutta is somehow appearing on behalf of orthopedic. Thereafter, we made a application before them asking to take steps.
What steps are you taking against this orthopedic hospital?
We have not right now, not yet, because we have already.
You only want to float on the back of the corporation.
No, Section 9 application was filed, arbitration, and now arbitration proceedings will start, but with Lions Orthopedic, not Calcutta. Arbitration proceeding is soon going to start with Lions Orthopedic Hospital. And also FIRs has been, complaints has been filed before police stations, Your Lordship. But there is no relationship with Lions, North Calcutta.
You have not yet mutated your name in the records of the corporation.
That I need to take instructions.
Because this is the order of the special officer. Please come.
Your Lordship, I can show the agreement that the agreement was made between Lions Orthopedic.
Achha. Learned advocate representing the contender. Is it you who handed over this order?
Yes.
Achha, learned advocate representing the
Just now I have received a report, my lord. Your lordship kindly. আর কপি আছে ওই জন্যই আপনাকে ফোন করেছিলাম
produces the copy of the interim order passed by the special officer within bracket building KMC on 11th of November 2024 initiated to deal with the unauthorized construction under section 400/400 within bracket 1 and 416 of the KMC Act 1980 in respect of premises number 160, NSC Bose Road, Ward number 98, Borough 10, XI. Dekhe nemen. Stop paragraph. It appears that the
11th of
July. এটা আগে already file করা আছে। This report, Your Lordship, my learned friend has handed it over. It has already been filed before.
11 July 2024. This is already on record. I have seen this. Achha. That the demolition proceeding is yet to be concluded. Stop paragraph. The concerned officer is directed to immediately conclude the demolition proceeding without any further delay. Stop. The contempt application stands adjourned till 6th March 2025 for filing affidavit of compliance.
Take on this submission, Your Lordship, that steps have been taken against clients North Calcutta.
I'm not concerned. What is important is the premises number. This is your internal dispute as to whether Lions is operating or the orthopedic hospital is operating from there.
Grateful to you.
Grateful, Lordship.
I'm for the petitioner, my lord. My lord, in the last occasion, Your Lordship directed me to serve notice upon the learned advocate who represented the respondent number 11 in the writ petition because corporation says she is dead. Now, my learned friend came in the last occasion and says
not
she
dead, my
is
lord. There are
alive.
still alive, my lord.
Therefore,
And
Lordship,
before the
kindly-
landed court bill also, my lord, the petitioner, before the landed court bill at Asansol, he has done so, my lord.
Therefore, my lord,
I have got
direct
information,
the concerned Association Municipal Corporation to conclude the
Hearing concluded, my lord.
I have no such
Most probably order has not been passed, most probably. কিন্তু আমার client submit করেছে document. My client went to the corporation office and document submitted the document.
Notice it has come back with a postal endorsement disease.
No, hearing was made, my lord, and submitted the relevant documents.
Successfully
As I got
submitted
information,
My client says, my lord.
Has hearing been done? You don't know?
No, my
What? Hearing not done?
No, my client says nothing has been done.
As I got information, my lord, the hearing that was fixed and he submitted the relevant documents.
The notice it came back to us.
Respondent number 11
notice করেছে কি বলবে কি করেছে কি জানি
appears in court and submits that the respondent number 11 is very much alive. Stop. Paragraph. The Asansol Municipal Corporation is directed to take steps for compliance of the order passed by the court. Stop. The notice of hearing may be served upon the concerned parties with additional copy to the learned advocate representing the parties before this court. Stop. Let an affidavit of compliance be prepared and circulated by 13th of March, list on 20th of March.
In that case, may I request Lordship would kind enough to fix date and time of hearing. No,
Why you?
Because all parties are present, everybody will be, because I'll serve
Your
notice. Lordship would kind
what
enough
the matter is, I do not know.
No, unauthorized construction. Unauthorized construction.
Unauthorized construction.
In terms of your Lordship.
No, I have got the plan, sanction plan, my lord. I have some relevant documents. I will
So
submit.
he says for fixing up a date.
Exactly, so that everybody knows it.
একটা কাজ করুন তাহলে আপনি লিখুন তো
February, kindly fixes up.
the date of hearing. ওই নোটিশের জায়গাটা কেটে দিন।
সেটা ভালো।
The date of hearing for consideration of the issue of unauthorized construction by consent of the parties is fixed on, give me a date.
Second week of February, Milord, from 10th to Milord 14th, 15th.
The client আমরা বলবো because
Give me a particular date. Second week of February will not do. When are your officers available? Every day.
There is no holiday, Milord.
No holiday in the second week at least. Right? In that case, 12th of February,
At 12 noon.
it's a Wednesday.
At 12.
12th February at 12 noon. Stop. The requirement of serving fresh notice of hearing upon the respective parties stands dispensed with. The parties are directed to appear in the hearing along with supporting documents.
Deeply.
my lord, both my lord, learned advocates to us and also the parties, my lord, if it is so.
For what?
It is fixed by
My lord, if it is so, my lord, if the notice is given to the parties,
Why? I have fixed the date of hearing. Why notice?
fix the date, my lord. Stating the date has been fixed. If the such notice is given to the
No notice will be given.
both parties and advocates.
None of the parties will be given notice. Notice is given here. If you want to create a problem, then the court knows how to solve it out.
No, my lord. I will implement. Today I will implement.
As it is, your client has been recorded as dead.
No, that is my lord. Manage, my lord. I have not managed. Petitioner has managed, my lord. Before the landed court will also, my lord, at assessor. Civil court, civil case is pending. Before
Now
that
you
also.
are aware that your client is alive and the date of hearing is
Yes,
there.
I am appearing on behalf of the petitioner, my lord. This
Order
is
was
the
passed on 21/12/2022, and as per the order, self-demolition notice has been issued on 13/6/23.
And we are in 25. What has happened?
nothing has been.
Self-demolition notice has been issued in 23.
Self-demolition is not the end of the matter.
My lord said, passing the order, but then I will, I will come with a compliance regarding fixing the date for demolition.
Order was passed, my lord, on
Please
21st of December
Because
2022.
the direction was to pass a recent order that has been passed. Thereafter, steps we will take it.
It has been brought to the notice of the court
13/6/23.
by the learned counsel representing the contender that the allegation of unauthorized construction made by the petitioner was duly considered, and on detection of unauthorized construction, order has been passed for self-demolition of the same on 13th of
June
2023. Stop paragraph. Fact remains that
order has been passed.
Despite the detection of unauthorized construction,
My lord passed the order that to pass a recent order.
steps, naki bolam, despite detection of the
Considering the representation and pass a recent.
and despite expiry of the time period for effecting the self-demolition, the unauthorized construction has not been demolished till date. Stop paragraph. It is high time that the corporation takes steps to implement the order of demolition
Self-demolition.
at the earliest. Contempt application stands disposed of.
My lord, if your lordship kindly see the second part of your lordship's order.
Yes,
my lord.
lordship passes this order. If anything, some steps will be
My lord,
taken.
kindly keep it pending. Otherwise, my lord, your lordship knows
This
what
order
will
is
happen. My
sufficient
lord,
to carry out the order.
kindly keep it pending, my lord.
This order is sufficient.
Call the next matter.
Advocate on record.
Lordship, I am for the municipality, Lordship.
I'm appearing for the petitioner, my lords. My lord,
May I permit to file the compliance report, Lordship? In the meantime, order has been fully complied, Lordship, as per my direction.
Has the order been complied?
no, my lord. Let my lord know the fact, what has happened. My lord has passed an order on 17th of July 2023.
Are you aware of this compliance?
No, my lord.
Give a copy.
Lordship.
My lord, since then, am I to bolte din? Since then, my lord, 3 to 4 times they have served notice to my client for that they will come and demolish. One after another false statement, my lord. Today they cannot come because of shortage of labor. Day after tomorrow they cannot come because of there is a election commission going on. All these things, my lord. Certain parts have been demolished, not the deviated plan, which is the demolition order passed by my lord to demolish within 12 weeks, my lord. From 2023 to 2025, my lord, only the asbestos shed of the top floor has been removed. I can show, my lord, the pictures.
But there are pictures to show that the walls have also been demolished to some extent at least.
Thereafter, Lordship, municipal authority at him for the demolition, and the entire construction has been demolished as per my instruction, Lordship.
This is the entire construction.
Lordship, kindly consider the photographs.
Today, my lord. Kindly consider, my lord. The iron shed is still there. Only the asbestos shed has been removed.
No, Lordship.
And which is the unauthorized portion? The entire building?
No, my lord. The
top
unauthorized
floor.
portion is as per the deviated fifth floor of part A and
Lordship, roof has been, Lordship, demolished with the wall.
they are each and every
This is
time.
the site plan.
Yes, my
You
lord.
are showing the site plan. And what
According to
is the unauthorized construction?
That is a deviated plan, my lord. It's a deviation made. Board of administrators, my lord. This is
For demolishing the deviated portion of the building.
and the deviated portion is my lord, in A, the entire 5th floor, and in B, my lord, the upper portion.
Upper portion and ground portion.
Ground floor and the upper portion. My lord, only the asbestos tin sheet has been removed.
Lordship, as per my instruction, Lordship, the asbestos portion with the floor on the top floor has totally demolished, Lordship.
What about the rest?
Lordship, nothing is there. Total
Ground floor
completely became inhabitable, Lordship.
Inhabitable is something else. If it has become inhabitable,
Lordship,
why
they
are you keeping it over there?
regarding the
Demolish
ground
it.
floor, Lordship. They are the complaint is for the unauthorized top floor, Lordship. As per my instruction, the top floor has been demolished.
The deviated plan is
This is the communication from your municipality which says the unauthorized constructed portion. This is your document.
Yes.
This is not the petitioner's document. And this is the photograph which shows that certain portion of the unauthorized construction still remains. And it is the same photograph which you and your learned friend is showing. It is the same thing.
Lordship, as per my instruction, Lordship.
Your instruction is incorrect because your photograph does not support your instruction.
They are just flouting my lord's order like anything. Each and every time they come and make false statements.
Please come.
My lord may appoint a special officer, my lord, who can go and see and give report.
The learned advocate for the petitioner asserts that the order passed by the court has been partially complied and the entire unauthorized construction, but the entire unauthorized construction is yet to be demolished. Stop. Photograph in support of the submission that portion of the unauthorized construction still remains has been produced before this court. Stop. Learned advocate representing the contender files an affidavit of compliance affirmed by the
Chairman of the Uttara Kottram.
chairman of Uttara Kottram municipality in support of the submission that the unauthorized construction has been completely demolished. Stop. Paragraph. The photographs produced by the learned advocate for the petitioner and the learned counsel representing the municipality are more or less the same. Stop. The photographs suggest that portion of the unauthorized construction still remains. Stop. The municipality is directed to take steps to demolish the remaining unauthorized construction strictly in accordance with the deviation plan prepared by the municipality and forwarded to the petitioner under the Right to Information Act. Stop. The contempt application stands adjourned till 6th of March.
I'm humbly praying
Further affidavit of compliance shall be filed on the adjourned date.
I'm humbly praying, my lord, if a special officer is appointed, my lord.
Let us see what can be done. The special officer will not know which portion is authorized, which is unauthorized.
6th of March.
কিছু মামলা আছে 4:15 বলুন কোনটা? Which one?
289.
Application 1 কোথায় আছে? কোথেকে আসছে?
Milord, subject to the leave of the court, Milord.
Okay, madam.
Application 1. Application 1. Application 1.
These content matters will not be taken up.
289.
Which one?
Next matter. Next matters will not be taken up.
এখানে আপনি লিখেছেন
Milord, sir.
application 1 will be taken.
Yes, my lord.
Yes, 289. Call. These
Well,
are all
subject
first
to the
time
leave of the court.
orders.
First time, my lord, new content.
289.
289. Wow, very good.
Yes, call 289.
अरे very good, you did for this.
আপনি ফাইলটা হাতের কাছে রাখেননি? Has the order been complied? Who is for the petitioner?
Well, I'm for the contempt petitioner.
Yes.
Well, the thing is that
No, don't tell me thing or anything. Has the
it's a
order
new
been
contempt.
complied?
Yes.
Order has,
No, contempt has not been complied.
order has not been complied?
Not bad.
Very well, serve notice. Come back on the 6th of March.
6 of develop.
Who is the contemptor? Pradhan of the Gram
Respondent number
Panchayat.
6.
Very well. Is this respondent still there?
No, respondent 6. No.
She is not the Panchayat Pradhan right
Now?
Right now. Yes.
You ought to have mentioned it. একটা paragraph add up করবেন তো, leave granted to the advocate on record of the petitioner to implead the present incumbent as contemptor in the contempt application and serve copy of the contempt application upon the added respondent. Stop. The added respondent shall be obliged to comply the order passed by the court. Returnable 6th of March. আজকে যেগুলো order হবে সেগুলো 6th March returnable.
Item number 325, first time contempt.
Develop.
290.
290, my lord, I am appearing on behalf of the petitioner, my lord. It is
Yes.
the first time appearing.
Yes. File. Rana Babu তাড়াতাড়ি দেবেন.
Lord, that order has not been complied.
Contempt you are sure? Yes, very well. Notice to be served.
Highly appreciated.
Returnable 6th of March.
Highly appreciated. Item number 325 also first time.
291.
Shivasi strategy.
Give your appearances, please.
Hi.
Yes. See, no, serve notice 6th of March.
Item number 325, first time notice.
292. Do not mention. All matters are first time.
292, I have for the petitioners.
Serve notice.
First time.
Yes, serve notice 6th of March.
Grateful.
293.
293, my lord, I am appearing on behalf of the petitioner, my lord, first time.
কোনোটারই ফাইল পাওয়া যাচ্ছে না? হ্যাঁ? 3. Serve.
Highly appreciated.
Yes, 294.
Lordship, I am for the petitioner first time.
Serve.
Lordship.
295.
My lord, I'm for the petitioner, appearing for the first time, my lord.
Appearance to be given.
My lord.
Serve.
My lord.
296. No order. 297. No order. 298.
My lord, I'm for the petitioner, first time, my lord.
Very well. 298. Serve. 299.
Lordship, I'm for the petitioner, lordship, first time, lord.
Appearance to be given. 300. No order. 301. No order. 302. No order. 303. No order. 304. 305. 306. 307. 308.
Lordship, I'm for the petition now.
308.
First time.
Please serve. Appearance, please. 309.
I'm for the petition, first time.
Serve. 3010. No order. Which is your item you said?
325, my lord.
1 minute. Yours, please.
It's 364, Lordship, and 379.
1 minute. 364 and 379.
Yes, ma'am. Yes.
First time.
Your first time.
Service.
368, my lord.
320, my lord.
My lord, 325.
No, I will not take any further. Enough has been taken today.
My lord, kindly 325. 324,